Chapter 2. Subrogation in cases where different parties buy successive claims upon this same property by mortgage, lien, or purchase. 12. Subrogation of a junior encumbrancer upon payment of a prior encumbrance. All persons having an interest in property subject to an encumbrance by which their interest may be prejudiced or lost have a right to disengage the property from such encumbrance by the payment of the debt or charge which creates it. And if such debt be one for which another party is ultimately liable, they will, upon their payment, be subrogated to the right of the creditor against the ultimate debtor, and against the property upon which he debt was a charge. A mortgagee can make no effectual resistance to a claim for subrogation by one who tenders to him his debt and costs, and who has a subordinate interest in the property, which would either be lost or seriously injured without the proposed substitution. So, a second mortgagee, who is in danger of losing his security by the foreclosure of the first mortgage, may redeem from the first mortgagee or pay the debt secured by the first mortgage, and may thereupon look to the mortgaged property for his reimbursement, even against intervening encumbrances. On the same principle, the lien of a pledge will cover freight paid by him upon the goods pledged. And as a carrier's lien for the carriage of the specific goods is prior to the vendor's right of stoppage in transitu, and the carrier may insist upon retaining possession until these charges are paid, an officer who pays these charges to the carrier in order to obtain the goods for the vendor is substituted to the carrier's right of possession until he is repaid. The general rule is that a lien creditor, on paying the mortgage or other lien which is prior to his own, is subrogated by law to the rights of the creditor whose debt he has paid. A second mortgagee who, to prevent a foreclosure of the first mortgage, redeems from it will be subrogated to its lien against an intervening or subsequent attachment, and an assignment of the mortgage will not be necessary for this purpose. Though a stranger cannot set up an outstanding satisfied mortgage as a basis of title to the property, yet the equitable owner of the land, whose debt it was not, but who has paid it in order to protect his property, may do so. But a release from a prior to a subsequent mortgagee, nothing more appearing, will operate merely as an extinguishment of the mortgage. 13. Subrogation will be made to serve the purposes of justice and the intent of the parties. There are cases, said Mr. Justice Parker, in which a party who has paid money due upon a mortgage is entitled, for the purpose of effecting the substantial justice of the case, to be substituted in the place of the encumbrancer, and treated as assignee of the mortgage, and is enabled to hold the land as if assignee, notwithstanding the mortgage itself has been cancelled and the debt discharged. The true principle, I apprehend, is that where money due upon a mortgage is paid, it shall operate as a discharge of the mortgage, or in the nature of an assignment of it, as may best serve the purposes of justice and the just intent of the parties. Many cases state the rule in equity to be that the encumbrance shall be kept on foot or considered extinguished or merged, according to the intent or the interest of the party paying the money, but the decisions themselves, it is believed, will generally be found in accordance with the principle above stated. There is another class of cases in which he who has paid money due upon a mortgage of land to which he had some title which might be affected or defeated by the mortgage, and who was thus entitled to redeem, has the right to consider the mortgage as subsisting in himself, and to hold the land as if it subsisted, until others interested in the redemption, or who held also the right to redeem, have paid a contribution. And it makes no difference in either of these classes, as I conceive, whether the party on payment of the money took an assignment of the mortgage or a release, or whether a discharge was made and the evidence of the debt cancelled. The debt itself may be held still to subsist in him who paid the money as assignee, so far as it ought to subsist, in the nature of a lien upon the land, and the mortgage be considered in force for his benefit, so far as he ought in justice to hold the land under it, as if it had been actually assigned to him. 14. Subrogation upon redemption from a prior encumbrance. One who has paid the money due upon a mortgage of lands to which he had a title that might have been defeated thereby has the right to hold the lands as if the mortgage subsisted and had been assigned to him, until he has received the amount due upon it from someone who has the right to redeem, whether he took a discharge or an assignment of the mortgage. The mortgage may, for his benefit, be considered as still subsisting, though formally discharged, so far as he ought in justice to hold the property. so an encumbrancer may redeem from a paramount tax title and be subrogated to it for his protection, even against a prior mortgagee, until reimbursed for his expenditures. A tenant for life or for years has the right to redeem from a mortgage which is prior to the creation of his tenancy, and upon redemption will be subrogated to the rights of the mortgagee against the mortgagor and the reversioner. And in New Jersey he will have the right, upon redemption, to have the bond and mortgage delivered to him uncancelled, which in equity will be equivalent to an assignment of them to himself. A mortgagee of a leasehold estate will have the right of subrogation upon redemption from a prior encumbrance. But the tenant cannot hold the land against a prior encumbrancer by simply paying the interest as it accrues. Nor can he, on paying the debt, require a formal assignment of the encumbrance. He can only redeem, and then claim his subrogation, and he must pay the entire amount of an encumbrance which is senior to his own estate, with whatever costs have accrued. 15. Subrogation of junior encumbrancer compelled to pay a prior charge. A mortgagee who has been compelled, in order to protect his title, to pay the amount due upon a prior mortgage will be subrogated to the rights of the prior mortgagee, and may hold the land for the sum so paid by himself, even against one whose title to the property has accrued after the discharge of the prior mortgage upon the record, if the whole amount claimed upon both mortgages is not greater than appears to be due by the record, and he may also hold for the payment of the debt secured by the prior mort. Gauge the parties who were personally liable therefor. If his payment was made to the authorized attorney of the first mortgagee, and that attorney embezzled the amount, and then transferred the first mortgage overdue to a stranger, yet the junior mortgagee will be subrogated for his protection to the prior lie of the first mortgage which he has thus paid. The payment by a junior mortgagee will not relieve the real debtor from his obligation. A mortgagee who purchases, at the request of the debtor, a paramount lien on the mortgaged premises, with the express understanding that it shall be tacked to the mortgage and paid out of the fund, is entitled to have it so tacked to his mortgage and paid out of the mortgaged premises. The necessary expenses incurred by a subsequent mortgagee to redeem from a prior mortgage which ought to have been paid by the mortgagor, or to remove a paramount right of dower, are justly chargeable by him upon the mortgaged estate. And if a junior encumbrancer takes up a prior encumbrance, which was also a lien upon other property than that to which he bade himself a claim, he may resort to that other property and enforce the lien thereon for his reimbursement. If the debt secured by the encumbrance which he has thus paid bore a higher rate of interest than his own, he will be allowed the increased rate of interest on his payment, subject to any legislative change in the rate of interest allowed. This right of a junior mortgagee cannot be defeated by any arrangement between the prior encumbrancer and the mortgagor, or by any adjudication of their respective rights to which the junior mortgagee was not a party. 16. Duty of prior to junior encumbrancer. In England, a mortgagee is required to convey and hand over the title deeds to any person having an interest in the equity of redemption, though only a partial one, by whom he is paid off. But the conveyance should be made subject to the right of redemption of all persons who hold other interests. When the party redeeming has only contracted to purchase an interest in the premises, the mortgagee need not convey until the purchaser has accepted the title. The prior mortgagee ought, without judicial proceedings, to accept an offer of payment made to him by a junior encumbrancer, and thereupon to convey to him the mortgaged estate, with or without the concurrence of the mortgagor. And if he refuses to do so on demand, and subsequently acquires from the mortgagor the equity of redemption, which was of sufficient value to pay the junior encumbrance, he will be himself held for the amount of the latter. 17. Junior encumbrancer's right of redemption. A junior encumbrancer or claimant has the right to redeem from a prior mortgage by paying the amount which is due according to its terms as recorded. The facts shown by the record cannot be contradicted to his prejudice. When he offers to redeem, the prior mortgagee cannot tack to his demand another debt due to him from the mortgagor, not a charge upon the premises sought to be redeemed of which the junior encumbrancer was bound to take notice. A latent equity of subrogation cannot be enforced against a subsequent bona fide purchaser for value without notice. Even a mortgagee's right of subrogation to the benefit of prior liens discharged by him, if not appearing of record, cannot be enforced against those who have taken interest. In reliance upon the record, to an amount greater than the total sum which the record shows to be due. As against the junior encumbrancer, no new terms can be incorporated into the prior mortgage, no new indebtedness can be secured by it. Thus, where the parties to the mortgage stipulated for the payment of a higher rate of interest upon the mortgage debt than was provided for by the terms of the mortgage as recorded, it was held that the excess of interest could not be made a lien upon the land to the prejudice of subsequent encumbrances or of purchasers without notice. Payments made by the mortgagor upon the indebtedness secured by the first mortgage cannot afterwards be transferred to another account, to the prejudice of a second encumbrancer, by the mortgagor and the first mortgagee. Where property was subject to the lien of a judgment, and then to 4 successive mortgages, and the holder of the judgment agreed with the fourth mortgagee to postpone his lien to that of the fourth mortgagee, and then sold the property under his judgment to the first mortgagee, who had no notice of this agreement, it was held that the first mortgagee was by his purchase subrogated to the lien of the judgment, and that the fourth mortgagee could not redeem from him without paying the cost of buying in the property under the judgment, as well as the amount which was due upon the first mortgage. And though this decision was reversed on appeal, the general principle was not doubted, but it was decided on the ground that the purchaser of real estate sold on execution acquires no other or better title than would have vested in the judgment creditor had the latter purchased the property. 18. When junior encumbrancer entitled to subrogation. Although a junior encumbrancer is entitled to redeem from a prior mortgage, and although, if he is not himself the principal debtor, but is compelled to redeem for the protection of his own lien upon the premises, he will upon redemption be subrogated for his reimbursement to the rights of the senior mortgagee. Yet, if the debt secured by his own mortgage is not yet due or payable, he cannot insist upon his right to pay off the first mortgage and to be subrogated to the position of the prior mortgagee, without showing that this is necessary for his own protection or for the preservation of his own security. Subrogation in equity proceeds upon the ground that it is necessary for the protection of the party who seeks it. And this will be the case when it is necessary for him, in order to get the benefit of his own security, to disengage the property from the previous encumbrance. Lie his own mortgage is payable, and he cannot get his payment without clearing away the previous encumbrance, or if the prior mortgagee is himself seeking to foreclose, then he may rightfully insist upon redeeming and upon being subrogated to the rights of the prior mortgagee. After a decree for the foreclosure of a prior mortgage has been rendered in proceedings to which the junior encumbrancer was a party, the latter cannot then claim a decree of subrogation or prevent the sale of the premises, unless he can show that the payment of the prior mortgage or its enforcement by foreclosure and sale would work him an injustice. His application comes too late. As mere junior mortgagee, his rights are sufficiently protected by the opportunity to purchase at the sale or to pay off the prior encumbrance before the sale. 19. Subrogation 1. Advancing money for the payment of an encumbrance. Where a person advances money to pay off a mortgage debt under an agreement with the owner of the equity of redemption or his representative that B shall hold the mortgage as security for his advance, but the mortgage, instead of being assigned to him, is discharged in whole or in part, B is yet entitled as against subsequent parties in interest to be subrogated to the right of the mortgagee and to enforce the mortgage. Though, if he was not intended to have the benefit of the former security for the debt which he pays, or which his grantor has paid, or if the subrogation is not necessary for his protection, or if he relied upon a forged mortgage, or if the agreement had been that he should depend upon a new security which was given to him, he could not be subrogated to the charge which bad thus been pie, and where a creditor, having taken on execution his debtor's lands, which were subject to a previous mortgage, subsequently paid off the mortgage with money which he borrowed for that purpose of a stranger, to whom he gave therefore a new mortgage upon the same land, and afterwards his levy proved to be defective, and the new mortgage was accordingly invalid as such, the new mortgagee was held, as against the debtor's grantee, to be subrogated to the rights of the prior encumbrancer, the payment having been necessary to avoid a foreclosure of the first mortgage. The same principle was applied in England in a case in which the plaintiff held a junior charge upon the company's property. Scheme of arrangement was confirmed by the court, by which the company was authorized to issue certain debenture of and debenture B stock. Debenture stock was to be applied, first, in payment of the mortgage debentures of the company and of certain costs, the stock applied for these purposes being preferred over the residue of the stock, which residue was to be applied in paying unpaid vendors of land. Debenture B stock was to be applied in paying off debentures of the company which were not secured by mortgage and in meeting other debts. The net income of the company was to be applied to pay, first, interest on preferred debenture A stock. Second, interest on the residue of that stock. Third, interest on debenture B stock. And lastly, such dividends as might be payable to stockholders. The plaintiff contended that he was not bound by the scheme, and that he had a charge on the income prior to the holders of the A and B stocks, on the ground that the original priority of former mortgagees and unpaid vendors of land who had accepted payment in these new stocks had been lost by the extinguishment of their original securities. But it was held that though he was not bound by the scheme, yet as it did not lessen his rights, so neither did it increase them. That he was not, therefore, entitled to such priority as he claimed, but that the net income must, in the first place, to an amount equal to the sums due upon liens which had been prior to the plaintiffs, be applied according to the scheme. So the lender of money borrowed by a corporation ultra vires may be subrogated to the rights of lawful creditors of the company who have been paid out of such money and allowed to recover from the company to the extent of the lawful liabilities so paid off. For the prevention of fraud, a person who advances money to pay off a mortgage, believing that it was the only lien upon the land, may be subrogated to the lien of that mortgage against a surety who has paid a judgment, which was a lien subsequent to the mortgage, and the payment of which appeared by the record to have been otherwise provided for. One who had paid off a mortgage debt under the mistaken belief that the title to the land was in his wife, while it really belonged to her daughter by a previous marriage, was allowed against the daughter a charge upon the land to reimburse him for this payment, but not for improvements which he had made upon the land. But a husband who, being sued with his wife for her debt contracted before marriage, and sectored by a mortgage upon her land, allows himself after her death to be defaulted in the suit, and pays the debt on execution, under the mistaken supposition that he can claim the amount of her estate at law, without taking an assignment of the mortgage, cannot be subrogated to the rights of the mortgagee for his reimbursement. For he paid the debt, not to protect an imaginary estate in himself or his wife, but under a mistaken belief of his legal liability therefor. Though a mere volunteer cannot by paying off a mortgage acquire an equitable lien or any right of subrogation, yet if he advances the money to redeem or pay off a mortgage at the request of one who is interested or bound to discharge it, he may be protected against such person by subrogation. A third party, who, at the instance of the mortgagor, pays a part of the mortgage debt, but takes no assignment of the mortgage, is not thereby subrogated to the rights of the mortgagee as against a subsequent encumbrancer. To effect such a subrogation, there must be something more than a mere payment of the money, and its silent receipt by the first mortgagee. Nor will he be subrogated to the benefit of the mortgage as against others who are secured thereby, by his having furnished the debtor with the means to make a partial payment of the mortgage debt, even though he holds the agreement of the mortgagor that he shall be protected by the mortgage. The mortgagor's agreement cannot prejudice the mortgagees, though it would bind the mortgagor himself. 20. Where new encumbrance given for old. Where a new mortgage is given for the same debt which was secured by a prior mortgage, which is thereupon discharged, the execution of the new and the satisfaction of the old mortgage have been treated as simultaneous and dependent acts, and if the new mortgage is invalid, its holder has been subrogated to the lien of the old mortgage. But if the new mortgage covers also an additional indebtedness, this subrogation can protect only what remains due upon the old mortgage debt. The same rule is applied where the new and defective mortgage is given to one who at the request of the debtor advances the money to pay off the prior encumbrance, the transaction being treated in equity as an assignment of the old mortgage to the new mortgagee. A forgery, if the old mortgage is retained undischarged and a new mortgage taken to secure both the old debt and the new advances, or if the old mortgage is contemporaneously with a payment assigned by the mortgagee to the one who advances the money to pay him, this will not operate a discharge of the former security. The authority of the California decisions cited above has, however, been somewhat shaken as to intervening liens of third persons by a later case I the same state. And elsewhere it has been held that a mortgage once understandingly and intentionally discharged cannot afterwards be reinstated to the prejudice of other claimants or encumbrances. And that where a mortgage has been discharged and its satisfaction acknowledged, and a new security taken upon the same land for the same debt, the lien of the old mortgage is gone once for all, and the new security must be postponed to such encumbrances as are prior to itself, though junior to the old mortgage. The old security ceases to have any validity upon the taking of a new security as a substitute therefor. If the new security is taken for the express purpose of gaining an advantage which could not have been enjoyed under the first will likewise be extinguished. As where a creditor who held a note secured by a mortgage upon a stock of goods, being told by the debtor that he had a number of notes coming due which he could not pay, delivered up his note and mortgage, and took a new note secured by a new mortgage upon the stock as altered and added to by labor, sales, and purchases, and it was held that he could not, upon the avoidance of his new mortgage, be subrogated to the lien of his former security. But if an intervening encumbrance were created without the knowledge of the beneficiary therein just prior to the execution of the new mortgage, with the fraudulent intention of giving it priority over the latter, it would not be allowed a preference over such new mortgage. And if a first mortgagee has accepted a new mortgage and surrendered his prior security for cancellation in ignorance of the existence of an intervening lien, equity will, upon his prompt application and in the absence of lashes or other disqualifying facts, restore him to his original position. If a mortgage has not been formally discharged, but the mortgagor has obtained from the mortgagee possession of it and of the note which it secures by means of a fraudulent pretense of payment, the mortgagee may yet foreclose the same, both against the mortgagor himself and also against those who have acquired rights under him in ignorance of the apparent satisfaction. A formal record discharge of a mortgage improvidently made by the administrator of the mortgagee, without the knowledge of the mortgagor and without consideration, will not necessarily discharge the mortgage, no other rights having intervened. A mortgagee or other lien creditor who has been induced to surrender his security by the mere fraud of his debtor may in equity have it reinstated and enforced as if no such surrender had been made. But innocent third parties who have, after such surrender and before the revival of the encumbrance, parted with their money upon the faith of the apparent surrender, will not be prejudiced by the revival. The same rule will be applied for the protection of the assignee of a mortgage which, before the recording of the assignment, has by mistake merely been discharged of record by the original mortgagee, and if intervening encumbrances, having come in without notice of his rights, are entitled to priority over him, he may upon paying them be subrogated to their rights. Where a mortgagor made a subsequent equitable charge upon his equity of redemption, and then requested the defendant, who had no notice of the charge, to pay off the mortgage, which was done, and a receipt was endorsed upon the mortgage, and the title deeds were banded over to the defendant, and the mortgagor then gave to the defendant a new mortgage to secure both the amount he had thus paid to the prior mortgagee, and also a new advance made by himself to the mortgagor, it was held that the defendant's subsequent mortgage had priority over the equitable charge, but only to the extent of the prior mortgage which he bad paid off. And even this limitation has since been disapproved. 21. Holder under a judgment lien subrogated upon paying prior encumbrance, where a judgment creditor levied his execution upon land, the whole of which was subject to a prior mortgage, and the debtor was entitled, as against the judgment creditor, to hold part of the land as a homestead, and had the same set off to himself, and afterwards the creditor was obliged to pay off the whole mortgage, which was superior to the homestead estate. It was held that the creditor was subrogated by his payment to all the rights of the mortgagee, and might enforce against the homestead estate the contribution of its proportional share of the mortgage debt. One who levies an execution upon an equity of redemption, and then pays off the mortgages to which his levy was subject, becomes by such payment the equitable assignee of the mortgages, and is subrogated to all the rights of the mortgagees in the mortgaged premises. So where the purchaser of an equity of redemption, at a sale thereof on execution against the mortgagor, paid off the mortgage and had it discharged, and then, on payment of the amount for which he had purchased at the execution sale, released to the mortgagor all the right he had acquired under the sale, it was held that he could afterwards recover from the mortgagor the amount which he had thus paid upon the mortgage. One who had purchased, under an execution against the divisi thereof, land which had been devised subject to a charge for a legacy, was allowed in equity, upon the legacy being afterwards charged upon the land, to recover the amount of the legacy from the divisi, but the creditor will not be allowed to use his right of subrogation for any other purpose than to obtain reimbursement for what he has paid upon the prior encumbrance. 22. Where encumbered lands sold under a junior lien. When the equity of redemption in mortgaged lands is sold under a judgment or a junior mortgage, which constitutes merely a subordinate lien upon the premises, and the sale has been consummated so that no right to redeem therefrom remains in the former owner, the purchaser at such sale is presumed to have bid only to the value of the equity of redemption, and the land which he has thus purchased becomes in equity the primary fund for the payment of the prior encumbrance. Such a purchaser cannot, upon paying and taking an assignment of the prior mortgage, collect the debt secured thereby out of the mortgagor's other property. The prior encumbrance is discharged by his payment, to the extent of the value of the property. On the contrary, if payment of the mortgage debt is then enforced by its holder from other property of the mortgagor, the latter will be subrogated to the mortgagee's lien upon the land, that he may indemnify himself out of the mortgaged premises, as he will be if upon his payment he takes an express assignment of the mortgage which he has given. And such a purchaser has no equity to require the mortgagee to apply to the satisfaction of his demand personal property, which is also embraced in his mortgage. But the rule is different before the consummation of the sale, while the junior encumbrance remains merely a subordinate lien upon the premises. Then the owner of the equity, if he wishes to preserve his estate, must redeem it from all die encumbrances to which it is subject, and the junior encumbrancer may pay off the debt secured by the prior lien and enforce it against the property. But there is no personal charge upon such a purchaser of the equity of redemption. If he takes an assignment of the prior mortgage and forecloses it, and sells the property for less than the amount of the debt secured thereby, he can then maintain an action for the balance of the debt against the mortgagor. Though the land has become the primary fund for the payment of the debt, yet the original debtor remains liable for what the land fails to pay, and the original debtor will have no defense to an action at law by the first mortgagee against him to collect the indebtedness secured by the mortgage, although another creditor has levied on his equity of redemption. He cannot compel the purchaser at the execution sale to redeem from the prior mortgage. He must himself, where the law gives him the power to do so, redeem both from the prior mortgage and from the execution sale, or lose the land. So, one who levies upon part of an equity of redemption, and then pays off and takes an assignment of the mortgages to which his levy was subject, becomes thereby entitled to the rights of the mortgagees in the whole of the premises. Where mortgaged land was successively attached by two different creditors of the mortgagor, and the first attaching creditor, having obtained judgment, levied on the equity of redemption, and sold it on his execution subject to the mortgage, and then the mortgagee released and quit claimed his right in the land to the mortgagor, it was held that the original mortgagor became thereupon invested as to the land with the character of a mortgagee, and that a deed of release and quitclaim given by him to the purchaser of the equity of redemption at the execution sale vested the whole title to the land in the latter to the exclusion of the second attaching creditor. 23. Subrogation of an assignee in bankruptcy. Assignees in bankruptcy will, upon redeeming pledges made by the bankrupt, be subrogated to the rights of the pledge, until the fund for general distribution is made good from the proceeds of the pledges redeemed. If the property of a bankrupt was subject both to attachments and to subsequent levies, it has been said that the dissolution of the attachment by the bankruptcy proceedings will not advance the levies, but the assignee will be subrogated to the priority of the dissolved attachments, though this proposition is neither self-evident nor universally admitted. And if a creditor of the bankrupt holding security for the payment of his debt proves it as an unsecured demand, and thereby waives high security, this will not extinguish the security for the benefit of other parties claiming the property subject to the rights of the creditor, paramount to the title of the assignee, but the assignee will, for the benefit of the general fund, be subrogated to the security thus waived by the creditor. but it is only the assignee who will be thus subrogated. A junior claimant of the security thus waived will acquire no advantage by the waiver. A junior lien, though valid against the assignee, will not be advanced by the assignee's avoidance of the prior lien. If the secured creditor proves his whole claim against the bankrupt estate, and thus diminishes the dividend of the general creditors, they, or the assignee as their representative, will be subrogated to his rights under his security, and allowed to enforce the same against those whose rights were subject to his. A creditor who has proved his demand against the bankrupt estate of one who is under a subsidiary liability for the debt, though entitled to receive his dividend, may yet be compelled by the assignee either to proceed himself at law against the ultimate debtor or to allow the assignee to do so in his name. 24. Subrogation of a mortgagor against a purchaser of the equity who assumed the mortgage. Where the purchaser of an equity of redemption who has agreed with the mortgagor to assume and pay the mortgage debt fails to do so, the mortgagor, if he is himself compelled to pay it, will be subrogated to the rights of the mortgagee against the mortgaged premises and may enforce the mortgage upon them, or he may look to tile personal responsibility of the purchaser, even though the purchaser has since sold the property. For, as between the mortgagor and such a purchaser from him, the debt rests upon the latter, and where one person pays a debt for another, being legally obliged to pay it, or having an interest in paying it, B is subrogated to all the rights of the creditor whom B has paid. So, according to the generally received doctrine, the mortgagee may himself enforce the performance of such an agreement by the purchaser. If the mortgagor in such a case, upon making the payment, obtains from the mortgagee a deed of release of the estate, he will, even at law, be regarded as the assignee of the mortgage. Where a mortgagee agreed with a mortgagor to look solely to the mortgaged premises for the payment of his debt, and to hold the mortgage bond rely as evidence of the debt, but in violation of his agreement took judgment on a warrant of attorney which accompanied the bond, and collected the whole amount of the debt from the mortgagor personally, the mortgagor was as against a second mortgagee from a lat or owner of the premises, subrogated to the rights of the first mortgagee in the mortgaged premises. If a purchaser from the mortgagor has agreed to assume and pay the mortgage debt, such purchaser and the original mortgagor stand to each other in the relation of principal and surety. The latter is quasi-surety for the former for the payment of the mortgage debt. The rule is the same if the payment, instead of being made by the mortgagor personally, is realized from the proceeds of collateral security deposited by him with the mortgagee, or by the levy of execution upon other property of the mortgagor. Each successive purchaser of the premises who assumes the payment of the mortgage becomes in his turn the party ultimately liable to bear the burden of the debt, and his payment will extinguish the debt. But such a purchaser's grantee with warranty, who has not assumed the mortgage and did not know of its existence, is not subject to the same equity as the original purchaser. 25. Rights of mortgagor against mortgagee and such a purchaser. When a purchaser of mortgaged premises has assumed the payment of the mortgage debt, the mortgagor cannot require the creditor to foreclose, but must himself, if the creditor so requires, pay his debt according to his agreement. He may then proceed against the land and the purchaser thereof for his indemnity. He can also proceed in equity to compel the purchaser, as to whom he stands in the position of a mere surety, to pay the debt for his protection. But the mortgagee may, if he choose, rely upon the personal liability of his debtor. High rights are not affected by the agreement between the mortgagor and the purchaser. For the principal debtor cannot acquire the rights of a surety against the creditor without the latter's consent. The mortgagee is not bound to look after or to protect the mortgaged premises. And if he finally forecloses the mortgage, the mortgagor is entitled to credit only for the net proceeds realized therefrom, and remains liable for any deficiency. The mortgagee can enforce for his payment both the personal liability of the mortgagor and the security of the mortgaged property. Equity will not, unless for special reasons, compel him to elect between his remedies. The mortgagor would have been protected in payment of the debt by his right of subrogation to the mortgage, which, as between himself and his grantee, would not be extinguished by being transferred to him. But B cannot be subrogated to the mortgage lien against his grantee until the mortgagee has been fully paid. And if the mortgagor has himself taken a second mortgage from his grantee, and has then assigned this for value to the first mortgagee, who took it without any knowledge of the assumption of the first mortgage by that grantee, the original mortgagor will not upon paying the first mortgage acquire any rights by subrogation prior to the lien of the second mortgage in the hands of the first mortgagee. The original mortgagor's subrogation in such a case will be only against his grantee who had assumed the first mortgage. 26. Subrogation of the mortgagor against his grantee subject to the mortgage. A conveyance of mortgaged premises by the mortgagor, subject in terms to the encumbrance, though the payment of this is not assumed by the grantee, will make the mortgaged premises, as between the mortgagor and the grantee, the primary fund for the payment of the mortgage debt. And if the mortgagee with notice of the facts releases the land after such a conveyance, he thereby releases the liability of the mortgagor. A. Second mortgagee who has taken a conveyance of the equity of redemption in terms subject to the payment of the mortgages cannot, after paying off the notes secured by the first mortgage, maintain any action upon them against the debtors thereon. His purchase of the mortgage extinguishes it and the debt it secures. The land is the primary fund for the payment of the mortgage debt in the hands of a mere assignee of the equity of redemption, or a purchaser thereof who has retained the amount of the debt out of his purchase money. Lie the mortgagor is afterwards obliged to pay the debt, he will be subrogated to the lien of the mortgage for his indemnity, but there will he no personal liability upon the grantee for its payment. The risk of the latter is limited to the estate in his hands. Such a purchaser cannot, upon paying off the mortgage debt, have the mortgage assigned to himself, and avail himself of it against his grantor, the original mortgagor, unless for special reasons. A. Conveyance of the mortgaged premises, made to the mortgagee by the mortgagor's grantee, who had assumed the mortgage, will operate a merger of the mortgage and a payment of the debt secured thereby, so that no action can be maintained thereon against the mortgagor. But if the grantor has warranted against the mortgage, or if it was agreed between the grantee and the grantor that the mortgage debt should be paid by the grantor, the original debtor, then the grantee, if obliged to pay the encumbrance, may set it up against his grantor, and the grantor payment will not entitle him to subrogation against the grantee. 27. Rights of co-mortgagees against each other. Where a third mortgage was held by three, one of whom also held the first and second mortgagee, and the latter began to foreclose the first mortgage, as he had a right to do, the other two were allowed against him to redeem from the first and second mortgages, with the privilege, if he refused to contribute to the redemption, of holding the premises against him until he should contribute his share, being subrogated by their redemption to the same rights against him which before redemption he held against them. A mortgagor has a demand against the mortgagee, which he has a right to set off against the notes secured by the mortgage, and these notes are in the hands of different assignees. The set-off should diminish the amount to be paid to each assignee ratably, and if one of them has extinguished the set-off, and the mortgaged estate is not sufficient to pay all, its proceeds should be so distributed that all shall contribute ratably to the extinguishment of the set-off and receive ratable shares of the surplus. 28. Subrogation of the purchaser of an equity of redemption on his payment of a prior encumbrance. The purchaser of an equity of redemption, which was subject to the encumbrance of 4 different liens, the payment of which they did not assume, having paid off the first 2 charges and a portion of the third, were held to be subrogated by their payments to the rights of the creditors under their respective liens, to the extent to which they had paid off the same, and were allowed to set them up against the holder of the 4th charge, on the principle that where one who is not personally liable for a debt secured by a mortgage or other lien is compelled to pay it in order to preserve his own property, and does pay it, he may be subrogated to the lien, although it has not been assigned to him. Though if he takes an assignment of it, this of course will only strengthen his position. This right of subrogation will also pass to a grantee of such a purchaser. And where the holder of the first encumbrance waived his claim to actual payment for the sole benefit of one holding an interest in the equity of redemption, and discharged his mortgage of record to such person without consideration, it was held that the encumbrance was not thereby extinguished as to a subsequent encumbrancer, but the holder of the equity in whose favor the waiver was made was subrogated to its benefit, and could set it up as a subsisting title. If a party who has the right to require an assignment of a mortgage pays the mortgage debt, and takes a discharge of the mortgage, the mortgage may be regarded as a subsisting security for his protection. B will be subrogated to the rights of the mortgagee. The rule that the payment of a mortgage debt by the owner of the equity of redemption will extinguish the mortgage does not apply to the payment of an encumbrance which existed before the conveyance to the owner of the equity, and which the latter is under no obligation to pay by such an owner of the equity of redemption pays the debt. The mortgage is to be treated assigned to him, if this is manifestly for his interest, and not inconsistent with the justice of the case, and if no contrary intent is clearly expressed or necessarily implied. And he will be entitled to the benefit of a personal judgment already recovered against the mortgagor for the debt. 29. Rights of such a purchaser. Where the purchaser from a mortgagor pays off the mortgage and has it discharged without more, equity will not subrogate him to the rights of the mortgagee against an encumbrancer whose lien is subject to the mortgage, but prior to the purchase. If, however, the purchaser has paid off the mortgage in ignorance of the subsequent encumbrance, he could, in spite of its discharge, claim the benefit of subrogation to its lien. Much more, if he made his payment and took the discharge relying upon the statements of the subsequent encumbrancer that the latter held no claim upon the property. One who purchases property subject to the lien of 3 mortgages, the first 2 of which he pays out of his purchase money, and has discharged, the third mortgage having been given to the endorser of certain promissory notes to secure their payment by the mortgagor, so as to save the mortgagee harmless by reason of his endorsement thereof, and then takes a discharge of the third mortgage from such endorser, the mortgagee therein cannot be subrogated to the lien of the 2 prior encumbrances which he has paid against the holders of the notes which were secured by the third mortgage, although the discharge of the third mortgage was in equity and efficacious against such holders. The only way in which he could have kept the prior liens alive against the parties interested in the third mortgage was by having them assigned to him. The bare purchaser of an equity of redemption in terms subject to the mortgage debt cannot be subrogated to the benefit of other securities held by the mortgagee for its payment. Having purchased the equity of redemption and nothing more, he acquires by his purchase no equitable control over such other securities. As between the original purchaser and such mortgagor, the land is the primary fund for the payment of the mortgage debt, and the mortgagor, if compelled to pay it, will be subrogated to the lien upon the land and entitled to reimbursement therefrom. 30. Purchaser, if his purchase avoided, subrogated to lien which he has paid. The purchaser of real estate, who, in order to save his property, has paid off a valid lien thereon, is entitled to be subrogated to this lien as against those who turn out to have a title to or lien upon the property superior to his own, but subject to the encumbrance which he has discharged, though the enforcement of this equity has been refused at law in Massachusetts. Where the purchase money paid for real estate, under a sale which is afterwards avoided, has been applied in the extinguishment of a valid mortgage, such purchaser will be subrogated to the rights of the mortgagee to the extent of the purchase money which has been so applied. And the owner will not be allowed to avail himself of the payment thus made by a purchaser under avoidable sale, and to recover the property free of the encumbrance, without making compensation to the purchaser to the extent of the payment which has gone to the benefit of the owner. If the purchaser of an equity of redemption has paid off the mortgage debt, but has neglected to record his deed from the mortgagor until after a creditor of the mortgagor has attached the equity of redemption, he will be subrogated to the lien of the mortgage upon the premises for the reimbursement to him of the amount which he has paid upon the mortgage debt. But if the attachment had been made prior to the purchase, though actually unknown to the purchaser, such purchaser, having really bought subject to the attachment, could not, after the land had been sold upon the attachment, have the sale vacated, and set up against the attachment the lien of a paramount encumbrance which he had paid out of his purchase money. So the purchaser by parole of part of a mortgaged tract of land, who has paid off the mortgage to prevent a sale of the mortgaged estate, will be subrogated to the lien of the mortgage upon the whole tract, and to the benefit of a judgment recovered thereon. The same rules will be applied to a purchaser whose money has discharged an encumbrance upon personal property. 31. Purchaser under a mortgage or charge subrogated to its lien. Purchasers of property under a valid decree in favor of creditors will be subrogated to the rights of those creditors. And if the creditors had no notice of a lien upon the property and are not bound by it, the purchaser will not be affected by such lien, though notified of its existence. Before their purchase, mortgaged property has been sold under a decree of foreclosure, and the sale has been confirmed by the court which ordered it, but subsequently on appeal this decree is reversed, and the mortgaged property is ordered to be again sold for the payment of the mortgage debt. The original purchaser, if he has paid his purchase money and it has been applied in payment of the mortgage debt, is entitled to be subrogated to the position of the creditor and to be treated as the assignee of the mortgage to the extent of the payment of the debt which he has thus made. And if the mortgagee had himself purchased at such sale, and had accordingly entered satisfaction upon his mortgage, the mortgage would, upon the sale being subsequently set aside, be set up again and enforced in equity. The purchaser at a sale made for the enforcement of a mortgage or other lien is subrogated to the rights of the original lien holder, even though the proceedings were invalid and his purchase has been avoided. Unless he secures a title under his purchase, the sale is treated as an equitable assignment of the mortgage to him, and his grantee takes the same right. If the proceeds of a sheriff's sale made upon existing mortgages have been applied in satisfaction of prior encumbrances, a subsequent mortgagee, who got nothing by reason of the insufficiency of the proceeds, cannot disregard the sale because the purchaser has failed to record his deed. Such a subsequent mortgagee would not, under any circumstances, be allowed to have the land resold without reimbursing the price of the former sale which had been applied upon the prior encumbrances. But if the purchaser ought himself to have paid the debt for which the sale was made, he cannot set up any title through the prior lien, but it will be deemed to have merged, and one who has purchased, not under a paramount encumbrance, but under an adverse claim, will not be subrogated to the former, merely because it was afterwards, without his privity, paid off out of his purchase money. 32. Rights of such a purchaser in California. It was held in California after a foreclosure sale had been avoided because the owner of the mortgaged premises had not been made a party to the foreclosure suit, that the purchaser at such sale must seek his relief from the consequences of the invalidity of the decree for the sale by proceedings in the foreclosure snit. Because by his purchase he had submitted himself to the jurisdiction of the court in that suit as to all matters connected with the sale. Upon his application, the court might set the sale aside and cancel the satisfaction of the mortgage, and authorize a supplemental bill for a resale of the premises to be filed and conducted in the names of the original complainants for the benefit of the purchaser, causing all parties interested in the premises to be brought in as parties or make such other orders as should protect the rights of all parties and mete out exact justice. In that state, it has also been held, with less show of reason, that the purchaser of property at a judicial sale made under a decree for the foreclosure of a mortgage is not entitled, merely as such purchaser, to have the satisfaction of the judgment under which the sale was made set aside, and to be subrogated to the rights of the plaintiff in the judgment, simply because the sale at which he purchased was void, and he acquired no title thereby. His money has gone to pay the plaintiff's debt, but he is without remedy. The general rule is otherwise. 33. Instances of such subrogation. Mortgaged land upon the default of the mortgagor was sold by the mortgagee to a purchaser, who afterwards conveyed the land to a second vendee with warranty. The mortgagor's heirs avoided the foreclosure sale by suit and recovered the land from the second vendee. The second vendee then sued the heirs of the first purchaser upon the covenants in his deed, and recovered judgment against them, which they paid. The heirs of the first purchaser then brought suit against the grantees with notice of the mortgagor's heirs to have the land sold for the payment of the original mortgage debt. And it was held that these plaintiffs should be regarded as the equitable assignees of the mortgage by subrogation to the rights of the mortgagee, the court saying, through Biddle C.J., that though subrogation is not allowed to voluntary purchasers or to strangers, unless there is some peculiar equitable relation in the transaction, and never to mere volunteers, yet a person who has paid a debt under a colorable obligation to do so, and in order to protect his own claim, should be subrogated to the rights of the creditor, and that since subrogation is allowed for the benefit of a purchaser of an immovable who uses the price which he pays in paying the creditors to whom the inheritance was mortgaged, this purchaser's heirs should be subrogated to the rights of the mortgagee whose debt had been paid by his purchase. The same principle was applied in Michigan for the protection of one who had purchased mortgaged premises from the widow of the mortgagor, in consideration of his paying her a small sum of money and redeeming from the mortgage, and he was allowed against the mortgagor's heirs upon their avoidance of his purchase, a lien upon the land for the amount which he had paid to redeem it with interest, less the value of the use and occupation which he had enjoyed. 34. Purchaser ordinarily subrogated to all the rights of his vendor. A. Purchaser will ordinarily be subrogated to all the rights of his vendor in the property, even though they are not expressly conveyed to him. Though he had notice of outstanding equities, he will not be bound by them, if his grantor could have defended against them as a bona fide purchaser without notice. Thus, one who holds property in pledge has a special property which may be sold or assigned, and his assignee will be subrogated to the rights of the original pledge. The assignee of one who has agreed to sell land is subrogated to his vendor's right of rescission. So, one who has in good faith and for a valuable consideration purchased the whole or a portion of a mortgaged estate from the mortgagee in possession will be regarded as the equitable assignee of the mortgage to the extent of his purchase money, both against the mortgagor seeking to redeem the estate and against parties interested in the estate by subsequent conveyances. The vendee of one who holds a bond for title to land acquires by his purchase all the interest of his vendor, that is, the right to require a conveyance from the owner of the land upon payment of the price stipulated in the bond, and the owner of the land and the holder of the bond, having notice of his rights, cannot rescind their contract so as to deprive him of this equity. The assignee of one who held a contract for the purchase of land will be subrogated to the equitable lien of his assignor upon the land for the return of a portion of the purchase money which he had advanced upon the contract failing through the default or the inability of the vendor. Such an assignee may also, upon making full payment of the price, be subrogated to the rights of the original vendor against the original purchaser. The assignee of a debt will take as an incident the equitable right to the collateral obligation of a third person, or to any collateral security held by the original creditor for its payment, even though a formal assignment has not been made. A maritime lien will pass to an assignee of the debt secured thereby. The claim of a vendee of land for a defect in the title, a conveyance not yet having been made, will pass to his grantee. Thus, where the purchaser at a judicial sale of land paid a part of the purchase money, and then, before taking a conveyance, sold his claim under his purchase to an assignee, who paid the residue of the price, and then a defect in the title was discovered, whereby the sale was avoided, this assignee was held to be entitled to have the whole amount that had been paid refunded to him, including the payment made by his grantor well as what he had himself paid. If the purchaser of real property at an execution sale before taking his deed accepts from a stranger the amount on payment of which the judgment debtor would have been entitled to redeem, and assigns to him the certificate of the sale, the stranger is thereby subrogated to the rights of such purchaser and entitled to a deed of the property. 35. When the purchaser pays debts with which the property was chargeable, the purchaser of land who pays off a lien upon it may be subrogated to the rights of the holder of the lien as against another encumbrancer, such purchaser not having assumed either of the debts. He has even been subrogated to an interest in the prior encumbrance upon making only a partial payment thereof. The purchaser from a divorcee whose purchase money has been applied in payment of debts of the testator will be subrogated to the rights of the creditors whose demands he has thus satisfied. And in Pennsylvania, a purchaser of real estate has been allowed to take an assignment of encumbrances which he had agreed to pay out of his purchase money, and hold under them against an encumbrance which he had not agreed to pay, but the existence of which he discovered after his purchase. If the purchasers from the importers of dutiable goods have, upon the bankruptcy of the importers, paid the duties in order to obtain the goods, they will be subrogated to the priority of the United States for their reimbursement, even though they have proved their claim against the estate of the importers in bankruptcy as an unsecured one. But this right of purchasers to be subrogated to the benefit of debts which have been paid by themselves or out of their purchase money is limited to their reimbursement for debts which constitute a prior charge upon the property which they have purchased. If they have voluntarily paid debts which could not have been enforced against them or against the property in their hands, if, for example, the purchasers at a foreclosure sale have voluntarily paid off a junior mortgage upon the property, they will have no right of subrogation to its lien. 36. Purchaser compelled to pay his vendor debt subrogated to creditor's rights against his vendor. A. Purchaser of land who, in order to save the property which he has purchased, is compelled to pay a debt which ought to have been paid by his vendor, will be subrogated to the benefit of the debt, and of any charge therefore upon the property of the vendor. And in at least one state, this equitable right of the purchaser has been preferred to the claim of a surety of the vendor for the debt which constituted the charge upon the land to be subrogated upon his payment of the debt to the security which was held by the creditor. A purchaser whose land has been taken upon an execution against his vendor is entitled, upon paying the debt, to be subrogated to the lien of the judgment against the remaining land of his vendor. If, however, he has paid for the land by giving bonds for its price, which are still unpaid, he may set off his payment against these bonds, even though they are in the hands of one to whom they have been assigned by the vendor. So, too, he may set off such a payment against notes, which he has given for the price of the land, while these notes are still retained by the vendor, even though the notes are by statute exempted from levy in the bands of the vendor like a homestead estate. But this set-off of such a payment by the purchaser against bonds given by him for the price of the land must be made first upon bonds which are retained by the vendor, before applying it upon those bonds which have been assigned by him. And if the purchaser, with knowledge of the assignment of some of the bonds, and with notice of the prior lien upon his land, pays the unassigned bonds to the amount of the lien, the assigned bonds will be thereby relieved from all liability on account of the lien. 36a. Purchaser's subrogation does not depend upon the validity of his title. The right of subrogation does not depend upon the validity of the title of the person claiming to be reimbursed for his payment in discharge of a valid encumbrance. It is merely necessary that his payment should have been made in good faith for the protection of an interest which he believed himself to have in the estate, and in discharge of a burden actually resting upon the property, so that his payment has increased the value of the estate for the benefit of those who turn out subsequently to be entitled to the title. The benefit of subrogation has accordingly been allowed to one who held merely an invalid or a verbal contract for the conveyance of the land which he has freed from an encumbrance. To the assignee of one who held such a contract, to one whose only title was under an invalid mortgage or under a voidable decree, to one who claimed only under a void or avoidable sale, even after the avoidance of the sale by order of court, to an unsecured creditor who has paid off a mortgage debt in compliance with an erroneous order of court, to a divorcee who has only a contingent remainder in the encumbered estate, and to one who holds merely an equitable lien upon the property. If he bona fide claims an interest, he is not a mere volunteer and may be subrogated. But he must show that he had or supposed he had some interest to be protected. 37. Limitation of purchaser right of subrogation. A. Grantee's cause of action against his grantor for any misrepresentation is personal and does not pass to any subsequent purchaser from the grantee. The subrogation of the purchaser will not ordinarily extend to a mere right of action which has already become vested in his grantor, such as an action for a deficiency in the quantity of the land which would have entitled the vendor to an action against the original owner for such deficiency. An express or conventional subrogation is necessary to vest this right of the vendor in his purchaser. Nor will one claiming under a quitclaim deed from a mortgagor be thereby subrogated to the mortgagor's right to defend against the mortgage on the ground that it was procured by the and of the mortgagee. Nor will the purchaser be subrogated to any right of his vendor of which the law forbids the conveyance, or which is excluded by necessary implication from the terms of the conveyance under which he claims. Where the vendor of land had a lien thereon for the price, which was superior to a mortgage subsequently given by the vendee, but sold the vendee's interest in the property, instead of the property itself, for the unpaid balance of the price, the purchaser of the vendee's interest at this sale was not allowed to prevent a foreclosure of the mortgage on the ground that he was by his purchase from the vendor subrogated to the vendor's equitable lien. The purchaser of the right to redeem from two mortgages or other liens, since he acquires only the interest of the mortgagor, cannot, upon taking an assignment of the first mortgage, set it up as a source of title against those who claim under the second mortgage. 38. Subrogation of the purchaser at an execution sale against the debtor. The purchaser of land at an execution sale holds merely a lien upon the land while the statutory period of redemption is running. If in the meantime it becomes necessary for the protection of his interest, he may be subrogated, upon discharging a prior lien created by the judgment debtor, to the benefit of that lien for his reimbursement. And if the proceeds of property irregularly sold at a sheriff's sale have been applied in payment of the owner's debts, that owner cannot recover the property from the purchaser without repaying to him the amounts so applied. The purchaser who has bought in good faith, and whose bid has discharged an existing lien upon the land, is subrogated to the rights of the judgment creditor to the extent of the lien which he has thus discharged. But if the judgment itself was void and created no lien, and the debt was not a charge upon the land, there is nothing to which the purchaser can be subrogated, and he has no rights against the judgment debtor. Whereas judgment debtor owned a lot of land, and the sheriff, on an execution against him, sold by mistake another lot to which the debtor had no title, and the purchase money was paid and applied upon the judgment, and the debtor surrendered his lot to the purchaser, both supposing it to be the one that had been sold upon the execution, but afterwards the debtor, discovering the mistake, regained the land and refused to refund the purchase money. The purchaser was allowed to recover the amount of the purchase money from him. The purchaser at an execution sale of property which is under attachment for the same debt is entitled, if it is afterwards subjected by a decree to the payment of the attachment, to be reimbursed out of the proceeds of the attached property for his payment upon the execution. And if the purchaser of attached property pays the price in discharge of liens which were superior to the attachment, he should be indemnified, if the property is afterwards decreed to be sold upon the attachment, by the reimbursement of his money in preference to the attaching creditor. So also, if an execution creditor takes from his debtor an assignment of the latter's interest in a personal estate, this assignment is valid to the amount of his demand. And if this creditor, to save his rights, afterwards purchases the same property from a sheriff, who sells it upon a subsequent levy made under execution senior to his own, though this latter sale is void, the creditor so purchasing will be allowed, as against the debtor, to stand in the place of the senior creditors whom he has thus satisfied, and to be subrogated to their rights. And generally, where an execution sale upon a valid judgment is voidable, and the debtor seeks to recover the property, if there be no fraud on the part of the purchaser, the latter will not be compelled to restore the property to the debtor without being reimbursed the amount which he paid, and which has gone to discharge the judgment lien. And in the same way the purchaser from a judgment debtor of property which has been sold on execution will be subrogated to whatever right of redemption the debtor has by agreement acquired in the premises. 39. Subrogation of such purchaser where the property recovered by third parties. It has been considered that the purchaser of property sold under an execution has the right in equity, if the property has been recovered from him or his vendor by another under a superior title, to be substituted for the judgment creditor to the original judgment lien, and to have the amount of his purchase money refunded to him by the defendant in the execution, even though he knew at the time of his purchase that the property belonged to another, and was not liable to be sold on the execution, and that if the property had been thus recovered from a vendee of the purchaser, in his suit for indemnity, need not show that he has reimbursed his vendee, to whom he only, and not the defendant in the execution, is liable. But this has also been strenuously denied, and the position maintained, with greater reason, that the purchaser at an execution sale is not subrogated to the rights of the judgment creditor against the debtor, if the property is afterwards taken from him by virtue of a paramount title in a stranger. Just as he cannot under the same circumstances recover back the amount of his purchase money from the creditor to whom it has been paid, and this on the ground that he is merely a voluntary purchaser of the debtor's interest in the property, and that it is only where the person paying a debt has the rights of a surety, or is compelled to pay it by legal process, or in order to save his own property, that equity substitutes him, even against the debtor, to the place of the creditor, and that a mere stranger or volunteer paying the debt will not be subrogated to the rights of the creditor, unless there has been an assignment to him or an express agreement for such subrogation. 40. Rights of a purchaser whose purchase is voidable by creditors of his vendor. One who has purchased property at a sale which may be avoided by the creditors of the vendor, whether B is an assignee for the benefit of creditors, a purchaser, or a voluntary grantee, will, after satisfying the claims of the attaching creditors, be subrogated to their rights, so as to enable him to hold the property against subsequent attachments. His purchase, at a sheriff's sale against his grantor, will give him a good title. And if the sale to him was good as against the vendor, so that he could require the vendor himself to discharge the debts for which the property was subsequently attached, he may, in New York, upon paying the judgment rendered under such attachment, take an assignment of the judgment against his vendor, and be subrogated to the rights of the judgment creditor against his vendor. If a grantee of land whose deed is voidable by the creditors of his grantor takes from a prior mortgagee of the property a quitclaim deed of all the latter's interest in the premises, though it expressly states that the mortgage is thereby cancelled and discharged, this will, if his grant is avoided by the grantor's creditors, be construed against them to operate as an assignment and not as a discharge of the mortgage. His right of subrogation is not destroyed by the avoidance by his grantor's creditors of the conveyance which he has taken. A wife's right of dower is not barred by her having released it in his deed of his real estate, which has been subsequently set aside as in fraud of high creditors. The whole doctrine rests upon the principle that merely constructive fraud without an actual wrongful intent will not prevent subrogation, though it would be otherwise with an active participant in the fraud. And this principle has been generally maintained in the later decisions, though with great diversity of application to the varying circumstances, and with much difference of opinion as to the existence of actual participation in the fraudulent scheme. But the fraudulent grantee will not by subrogation or any other device be reimbursed for payments made by him in furtherance of the fraud. 41. Waiver of the right of subrogation. The right of subrogation may be lost by the waiver of the party entitled to it. Thus, where one of two whose estates were subject to a common lien paid off the whole debt and took an assignment of the mortgage, it was held that B might either regard the mortgage as discharged and bring an action against the other for contribution, or treat it as a subsisting charge upon the estate until the other should redeem by paying a reasonable contribution. Certain mortgaged premises being subject to a paramount lien for taxes, the first mortgagee before foreclosure paid the same, under an agreement with the second mortgagee that the latter, if he purchased the premises at the foreclosure sale, should repay the amount. The second mortgagee did so purchase, and the estate was conveyed to him. He then refused to refund the taxes, and it was held that the first mortgagee could not now, after his conveyance, be subrogated to the original tax lien. Though in general a junior encumbrancer who pays off the holder of a prior lien is entitled to be subrogated to the benefit of the latter's security, yet this right will be waived by an agreement of the junior encumbrancer that the property shall be otherwise appropriated. A long delay without action will be fatal to a claim of subrogation. 42. What is not a waiver? The right of subrogation to a recorded mortgage will not be lost by the mere failure to give notice of the claim to a purchaser for value. The fact that one entitled to subrogation obtains also collateral security for his protection is not of itself a waiver of his right. A mortgagee who is entitled to be subrogated to the benefit of a prior lien which he has discharged will not be deprived of this right, even though he has taken a new mortgage upon the same premises for the amount of his payments, and this new mortgage has been afterwards avoided for usury. But it is to be observed that this agreement for usury was not made until after the right of subrogation had vested. If, however, the claim had grown out of the usurious agreement, instead of being prior to it and independent of it, it could have furnished no basis for subrogation. Where one who was in treaty for the purchase of personal property, which was subject to two mortgages, paid off the first mortgage, under an agreement that until the completion of the sale he should stand in the place of the mortgagee and have the benefit of his security, it was held that he was not deprived of this conventional subrogation by the fact that his agreement with his vendor contained a recital that the amount so paid by him had been paid by him out of the purchase money and in discharge of the mortgage debt. 43. Right lost by negligence resulting in prejudice to others. The fact that the loss of one who seeks to be protected by the application of the doctrine of subrogation arose from his own negligence, and that the granting of his request would now be prejudicial to other innocent creditors or assignees of his debtor, will be fatal to his claim. Thus, where the owner of land conveyed it to another, and took for the purchase money a mortgage upon the property, and the parties agreed that the deed should remain unrecorded until the land should be surveyed, and the mortgagor stated to the mortgagee that he intended to sell the land to one D, and promised to transfer D's mortgage instead of his own, to which arrangement the mortgagee assented, and the mortgagor did convey to D, who recorded his deed without notice of the prior mortgage, which was not recorded until after the conveyance to D. It was held that the original mortgagee was not entitled to the benefit of the mortgage given by D in preference to the other creditors of his debtor's insolvent estate, and where a grantor sold land, taking no security for the payment of the purchase money, and his grantee sold the land to another, and took divers bonds for the purchase money, it was held that although the original grantor, by virtue of his equitable lien upon the land, might have subjected these bonds to the payment of his claim, while they were in the hands of high grantee, yet he lost this right by delaying to enforce it until after the bonds had been assigned to bona fide holders for value without notice of his claim. But the mere fact that the loss of the party seeking to be subrogated arose from his own negligence will not debar him from the right, unless its enforcement would be prejudicial to others who are not at fault. 44. The party seeking subrogation must not be in his own wrong. Anyone who seeks the benefit of the equitable doctrine of subrogation must come into court with clean hands. It will not be applied to relieve a vendee from the consequences of his own wrongful act, or of a wrongful act in which he has participated, or of the wrongful act of one under whom he claims. Accordingly, a vendor who seeks to rescind the contract of sale and to recover the property by reason of the fraud of the vendee will not be obliged to reimburse the fraudulent vendee for his expenditures made to carry out the fraud, although upon recovering the property he will reap the benefit of these expenditures by the discharge of a lien upon the property which they have paid, though it has been said that in equity where the party seeking to avoid a sale has been benefited by the fraudulent purchasers having paid off encumbrances, the purchasers should be reimbursed for such payments. Where the second mortgagees of a railroad company purchased the road under an execution against the company, formed themselves into a new corporation, and as such operated the road for their own benefit, and then the new corporation, to prevent a foreclosure, paid the debt secured by the first mortgage, after which their own purchase of the road, at the suit of creditors of the old company, was set aside as fraudulent and void. It was held that the new corporation could neither recover back the amount it had paid to the first mortgagees, nor yet be subrogated to their rights under their first mortgage. If a creditor who might otherwise claim to be subrogated to the lien of a mortgage upon his debtor's property, which he has paid off, has taken for his security another mortgage from the debtor upon the same property, which is found to be fraudulent and void as against the debtor's other creditors, he will not be allowed such subrogation to the prejudice of parties who have purchased the property at an execution sale against the debtor. 45. When one entitled to be subrogated to a lien may demand assignment thereof. The right of subrogation to the benefit of a prior encumbrance is sometimes enforced by compelling an assignment of the prior lien to the party entitled to be subrogated thereto. But the mere right of redemption and of subrogation will not of itself entitle a party to require an assignment, although this has been maintained in some cases. The right to demand an assignment is now generally limited to cases in which the party who is entitled to redeem, and thereupon to be subrogated to the benefit of the lien from which he redeems, is also in effect a surety, or is in equity to be regarded as a surety, for the payment of the debt secured thereby. Any one having a subsequent encumbrance upon the mortgaged estate can protect his interest by paying the prior mortgage when it is due, and he thereupon succeeds by subrogation, upon settled principles of equity, to the rights and interest of such prior mortgagee in the lands, as security for the amount so paid, without any assignment or transfer by the prior mortgagee. He is not entitled to an assignment. Where one is entitled to an assignment of a prior mortgage, he must actually tender the full amount of principal, interest, and any accrued costs to the mortgagee. Merely saying what he will do and paying the money into court will not stop the running of interest on the mortgage debt, and the right of any parties junior in interest to compel the assignment to them of a prior mortgage has been utterly denied. The mortgagee, says Mr. Justice Colt, is not required to observe or to regard the equitable rights to contribution which may exist between parties having different interests in the equity, or to protect them by transferring his title to anyone. When such rights exist, they are protected on those settled principles of equity, by which one who assumes more than his share of the common burden is subrogated to the rights of the mortgage to hold, without any assignment or act of transfer, as quasi-assignee, for the purpose of compelling contribution. He becomes in effect the assignee of the mortgage, for the purpose of enabling him to compel a contribution. But the right of subrogation arises by operation of law only when there has been a payment and extinguishment of the mortgage by one entitled to redeem. An assignment implies the continued existence of the debt, and the equitable right does not arise. 46. The real debtor cannot be subrogated. The debtor upon whom rests the ultimate obligation of discharging the debt cannot by his payment acquire any right of subrogation, and if, upon making his payment, he takes an assignment of the security, this will be equivalent to a discharge thereof. One whose duty it is to pay the taxes upon real estate cannot obtain any title in himself by neglecting to pay them, and either buying the property himself at the tax sale or afterwards purchasing it from a third party who had bought at such sale. An assignment of a judgment to one primarily bound to pay it will not keep it alive. One who has given 2 mortgages upon the same land with warranty cannot, after the titles under the 2 mortgages have been united in one person, and the second mortgage has been foreclosed, redeem from the first mortgage, and claim to be an equitable assignee thereof, and to be subrogated to the rights of the first mortgagee, so as to enable him to open the foreclosure of the second mortgage. For no debtor can be subrogated against his own warranty, nor can he be subrogated to the rights of the second against the first mortgagee. A purchaser cannot be subrogated to the benefit of an encumbrance which he has agreed to pay. One who has assumed and agreed to pay 2 encumbrances cannot be subrogated to the lien of the second, and his agent who made the bargain, and so knows its provisions, is under the same disability. If he himself held the first mortgage, that is extinguished by his assumption of both burdens. So, if the purchaser of land which is encumbered first by a mechanic's lien, and then by a mortgage has assumed and agreed to pay the mortgage debt, his purchase of the land, when sold under a judgment recovered upon the mechanic's lien, will give to him or to his grantee no title that can be set up against the mortgage. The purchaser of an equity of redemption is entitled to the benefit of a payment made by anyone whose duty, as to him, it is to pay the mortgage debt. But the mere fact that the money paid to a mortgagee comes from the debtor will not necessarily operate a discharge of the mortgage, if that is, as a part of the same transaction, assigned to a third party for value. Upon payment of a mortgage debt from the funds of the debtor and also from those of a third party, the mortgage can be kept alive only to the extent of the latter funds. 47. Assignment to one who is bound to pay the debt tantamount to a discharge. Just as an assignment is not necessary where the right of subrogation exists, so where one who has the right to redeem property from a mortgage or other charge pays the amount due and takes an assignment of the security, this will be treated as thereby discharged or as still subsisting, as the justice of the case may require. The party who is ultimately liable for a debt cannot, upon taking an assignment thereof, enforce payment from one under a merely secondary liability. Thus, an assignment of a mortgage to a former owner of the equity of redemption who has conveyed the mortgaged premises with warranty extinguishes the mortgage. The assignee takes it for the benefit of his grantee with warranty, and the assignment is tantamount to a discharge. So, if a purchaser of mortgaged premises who has by his deed assumed payment of the mortgage debt, or the grantee of such a purchaser, takes an assignment of the mortgage, this operates a discharge, and the lien of the mortgage is gone. And the same principle will be applied to a tax title. If the purchaser of mortgaged property, who has agreed with his grantor to assume and pay the mortgage as a part of his purchase money, causes the conveyance of the property to be made to a third party instead of taking it to himself, and then obtains an assignment of the mortgage to himself instead of having it discharged, this will as to the vendor operate an extinguishment of the mortgage. The rights of such third party are no greater than those of the original purchaser. So also one for whom property is held in trust, and whose equitable duty it is to pay a mortgage upon the property, though he may not be legally bound therefore, cannot, after paying the mortgage debt, keep the mortgage alive by procuring it to be assigned to himself or to a third person for his benefit. His payment discharges the mortgage. By an arrangement between two mortgagors, one of them assumed the payment of the whole debt and gave to the mortgagee a new mortgage upon the same and other property to secure both the old debt and a new indebtedness of his own, the former joint mortgage being also retained by the creditor as collateral security. A purchaser of the property covered by the new mortgage then paid off the latter security and took an assignment of the old joint mortgage, and this transaction was held to operate a discharge of the old mortgage. 48. Subrogation of a dowress who has paid a paramount lien on the property. A widow who was entitled to dower, but had not yet had it assigned to her, remained in the mansion house of her deceased husband with her infant children, whom she supported. She then paid a balance of the purchase money which remained due upon the property, and which was secured by a vendor's lien thereon, and she also paid out money for the taxes upon the property and for improvements. And it was held that she should be subrogated to the liens upon the property, which existed respectively for the purchase money and for the taxes which she had paid, except so far as it was her duty as dowress to pay the same, though she had no lien for what she had spent in making improvements. She is entitled to be subrogated to a lien which she has paid off, in order to preserve the property in which she thus has an interest. 49. Widow's right of dower against a purchaser who has paid an encumbrance to which her dower was subject. As the purchaser of an equity of redemption may be subrogated to the lien of prior encumbrances which he has paid in order to preserve his property, without having been under any personal obligation for their payment, so a fortiori, if such a purchaser takes an assignment of a previous mortgage, this will not operate an extinguishment of the lien of the mortgage. And if the mortgagor's widow was entitled to dower or homestead as against such purchaser, but not as against the mortgagee, then, after such an assignment from the latter to the former, she cannot have her dower or her homestead without redeeming from the mortgage, which, however, she will have the right to do. A quitclaim deed of the mortgage premises from the mortgagee to such a purchaser, after a breach of the condition of the mortgage, is a sufficient assignment of the mortgage. The mortgage will be kept alive where this is manifestly for the interest of the party who has paid it, and is consistent with the justice of the case, if no contrary intent is expressed or manifestly implied. In other words, the mortgage will be kept alive for the benefit of one who has paid it, where he is evidently entitled in equity to be subrogated to it, and does not appear to have done anything to waive the right, though it is sometimes said that if the purchaser has simply paid off the mortgage and had it discharged, not having taken an assignment of it, or in any way indicated an intention to avail himself of its lien, he cannot set it up against the claim of the mortgagor's widow for dower. The release of dower in a mortgage deed works an estoppel, not only in favor of the mortgagee and the direct assignees of the mortgage, but also of those who by subrogation become entitled to its benefits. The dower rights of the mortgagor's widow, having been released in the mortgage, though valid against the purchaser of the equity, must remain subject to the mortgage after this has been assigned or quitclaimed to the purchaser, and a redemption from the mortgage through process of law by such a purchaser will give him the same right, to the extent of the actual cost of the redemption. If a new mortgage has been given by such a purchaser expressly as a substitute for the old mortgage, the widow's rights will be no greater against the holder of the new mortgage, or against one who has redeemed from it, than they were against those claiming under the old mortgage. But where a husband, by falsely representing that he was unmarried, obtained a loan on a mortgage in which his wife did not join, and therewith paid off prior liens upon the premises, the mortgagee's estate was not allowed to override her inchoate rights of dower. For the wife is not in privity with her husband in regard to transactions to which she is not a party, and his frauds cannot be imputed to her. The mortgagor's assignee in insolvency is to be regarded as a purchaser who is not bound to pay the mortgage debt, and an assignment of the mortgage to him will not extinguish it for the benefit of the mortgagor's widow. The same rules apply to a purchase of the equity of redemption by the mortgagee as to an assignment or quitclaim of the mortgage to a purchaser of the equity as to its effect upon the rights of the mortgagor's widow. The mortgage will not be regarded as extinguished, so as to let in the widow's claim of dower, which was released in the mortgage, unless the debt has been paid by her husband, the mortgagor, or from his means, or by someone who stands in such relation to him as to be in legal effect the debtor, whose duty it is to pay and discharge the mortgage debt. 50. Dower let in if debt paid by one bound to pay it. If, however, the mortgage debt has been paid by one bound to pay it, then the mortgage will be regarded as extinguished, whether or not it has been assigned to the party making the payment. Whether any particular transaction shall be held to operate as a payment which extinguishes the lien, or as an assignment which preserves and keeps it on foot, does not depend so much upon the form of words used as upon the relations subsisting between the parties advancing the money and the party executing the transfer or release, and their relative duties. If the money is advanced by one whose duty it is, by contract or otherwise, to pay and cancel the mortgage, and relieve the mortgaged premises from the lien of the mortgage, a duty in the proper performance of which others have an interest, it will be held to be a release and not an assignment, although in form it purports to be an assignment. If the payment is made by an heir at law of the mortgagor, pursuant to the terms of a bond given by him to the administrator to pay the debts of the deceased, in order to prevent his real estate from being sold therefore, this payment will extinguish the mortgage in favor of the widow's claim to dower. If the mortgage debt has in substance been paid from the means or estate of the principal debtor, this will let in the widow's claim to dower, which was barred by the mortgage. 51. The widow may redeem her rights thereupon. A widow who is entitled to dower in an equity of redemption may redeem the estate by paying off the whole of the mortgage debt, and upon so doing she will, without specific proof of her intent at the time of payment to keep the mortgage alive, be subrogated to the place of the mortgagee for her protection and indemnity, until the heirs shall reimburse her their equitable proportion, and thus redeem from her all that is not comprehended in her claim of dower. When another claiming, like herself, under the mortgagor, redeems the mortgaged estate, she may share in the benefit of the redemption, upon paying her equitable proportion of the mortgage debt, according to the value of her dower interest. Or she may be assigned her dower in the excess of the value of the estate over the amount of the mortgage debt. An assignment of the mortgage to her will not merge her dower interest. And a wife who is joined with her husband in a mortgage of both his land and his personal property has, after the death of her husband, an equitable right to have the mortgaged personalty first applied to the payment of the mortgage debt, both against the mortgagee and also against the general creditors of her husband's estate. If she is given a mortgage of her own real estate merely to secure a debt of her husband's, she is entitled to have his interest in the estate as tenant by the courtesy first sold and applied to pay the debt, in exoneration of her own interest in the mortgaged premises, even against another creditor of her husband, who holds a general lien upon high interest in the premises, created subsequently to the execution of the mortgages. But if she is joined with her husband in a mortgage of his real estate, she is not entitled to have the debt satisfied exclusively out of her husband's interest in such real estate, so as to give her dower out of the whole estate, notwithstanding the mortgage. She can be endowed only in the equity of redemption, except as against those entitled to her husband's estate, in the case of the mortgage debt being his personal debt, which she may require his representatives to pay out of his personal estate. 52. The rule in Massachusetts. The rules adopted in Massachusetts applicable to all these cases have been succinctly but fully stated by an eminent judge as follows. First, when a purchaser pays off a mortgage to which the right of dower would be subject merely to clear the estate of the encumbrance, and not by virtue of any obligation to pay the mortgage debt, and takes an assignment or a conveyance of high interest from the mortgagee, he may stand on the mortgage title if he please, and then no dower can be assigned without payment of the whole mortgage debt by the demandant. Second, if in such ease the mortgage be discharged, then he will be held to have redeemed, and the widow will take her dower in the equity or by contribution, as she may elect. Third, but if the mortgage debt be paid by the debtor, or from his property, or in his behalf, then the payment will be treated as a satisfaction and discharge of the mortgage, and the widow will be remitted to her full right of dower. Fourth, the payment will be held to be made in behalf of the debtor when there is an obligation imposed by the grantor upon the purchaser to assume and pay the debt as his own, or when the grantor furnishes the means for the payment, as where, by the terms of the conveyance, the entire estate is sold, and the seller leaves a sufficient part of the purchase money in the bands of the grantee for the purpose. In such cases, if the purchaser take an assignment of the mortgage to himself, he will not be allowed to set it up, but the legal title thus acquired will be held to merge in the equity. 53. Assignment of a mortgage to the owner of the equity of redemption will not necessarily extinguish its lien. The payment of the money due upon a mortgage debt by the owner of the equity of redemption, who is not the debtor and is taking an assignment of the mortgage, will operate as a payment or as a purchase of the mortgage, as will best serve the ends of justice and the proper intent of the parties. Where the purchaser of an equity of redemption made a second mortgage thereof, and while this was outstanding, took an assignment of the first mortgage, which be soon after assigned to a third person, it was held that the existence of the second mortgage at the time of these assignments prevented the merger of the first mortgage. The assignment of a mortgage to one who has purchased the equity of redemption will or will not operate an extinguishment of the mortgage, according to the interest of the party taking the assignment and the just intent of the parties. If the owner of mortgaged premises conveys different parts of them to separate grantees, and one of these pays and takes an assignment of the mortgage, he can, in the absence of circumstances which would make this inequitable, hold it against all the mortgaged premises. And if the purchaser of a bare equity of redemption, which is subject to two mortgages, takes an assignment of the first mortgage for the protection of his title, this mortgage will not be thereby merged in the equity, so as to give to the holder of the junior mortgage a preference in payment out of the proceeds of the mortgaged property. And generally a mortgage which is assigned to one, not being the debtor, but having an interest in the mortgaged premises, is not thereby extinguished if it is for the interest of the assignee to uphold it. This equitable doctrine of subrogation has so far been adopted at common law as to prevent a merger. If the equity of redemption was subject when purchased to an attachment against the mortgagor which was junior to the mortgage, this will prevent a merger of the mortgage upon an assignment of the latter to the purchaser of the equity. 54. Test by which merger is determined. Nor is it necessary that the intent to keep the mortgage alive should have been manifested at the time of the payment otherwise than by taking an assignment of the security. Unless there appears to have been an intention to extinguish it, it will be taken to be subsisting or extinguished, as the interest of the party may require. The merger of a charge in the inheritance will not be presumed, if this would be contrary to the interest of the owner of both the charge and the inheritance. The merger is prevented and the charge or mortgage upheld whenever there is a strong equity in favor of it, but never where it is not for an innocent purpose. If they are held in different rights, there will be no merger. When a charge on an estate becomes absolutely vested is the owner of the inheritance, the tests usually applied for ascertaining whether the charge has merged are, first, whether there has been an actual expression of intention to that effect. Secondly, whether the acts done by the owner of the estate are only consistent with the maintaining of the charge, and thirdly, whether it is for the interest of the owner that the charge should not be merged in the inheritance. 55. Encumbrance so assigned, kept alive only for a good purpose and to protect a beneficial interest. The owner of an equity of redemption who has taken an assignment of the mortgage cannot keep it on foot to the prejudice of a bona fide purchaser under himself, nor unless some beneficial interest is shown to require it. And if the payment appears to have been intended at the time to extinguish the charge, it will have that effect. When the owner of the equity paid the amount which was due upon the mortgage, without then manifesting any intention of keeping the mortgage in force, and without any agreement for an assignment of the mortgage, but many years afterwards took an assignment of the mortgage and the notes secured by it, this transaction was held to operate a discharge of the mortgage. But it is a general rule that where a discharge of a mortgage has been taken inadvertently, and under a mistake of fact, equity will keep the mortgage alive and treat the transaction as an assignment, when necessary to protect the rights of the parties. 56. Mortgage assigned to the principal debtor is extinguished. If the mortgage debt is paid by the principal debtor or out of his funds, it cannot be kept alive by being assigned to him or to a mere agent for him, and the grantee of a mortgaged estate who has accepted a deed of the equity of redemption without covenants will be held, in the absence of a special contract and without some special circumstances, to take the land charged with the encumbrance, as between himself and his grantor. Accordingly, he cannot, after paying off the debt, keep it alive against his grantor by having it assigned to himself, so as to enable him to set it off against any unpaid balance that he may owe to his grantor upon his purchase. But if a mortgage has been assigned to the owner of the equity under such circumstances as to be tantamount to an extinguishment of the security, yet this owner, after assigning it as a valid instrument, will be estopped from claiming that it has become merged or extinguished, and such owner's grantee with notice of the circumstances will also be estopped. And an assignment of a mortgage made to the principal debtor, merely as an intermediary or a trustee, will not necessarily extinguish the mortgage. So, although the purchaser of an equity of redemption has expressly assumed and agreed to pay the mortgage debt, so that an assignment of the mortgage to him would operate an extinguishment of its lien, yet if, when he pays the debt, he takes an assignment of the mortgage in blank instead of a discharge, and subsequently reissues the mortgage to a creditor of his own, filling up the blank in the assignment with the name of such creditor, the mortgage will be kept on foot even against a subsequent purchaser from him with warranty. 57. Conveyance of the equity to the holder of a prior encumbrance will not extinguish it in favor of a junior. If a prior encumbrancer acquires the absolute title to the encumbered property, his prior charge will not be merged in the absolute title, where his interest and the intention of the parties unite to prevent the merger. He may still claim under his prior title, and the holder of the junior lien may still redeem from him as before, or the equity of redemption from the junior lien may still be foreclosed. The estates of the mortgagor and of the mortgagee, though united in the same person, will still be treated as distinct, when this is necessary for just purposes and to effectuate the proper intention of the parties. Though the purchase of the equity of redemption by the mortgagee generally operates to extinguish the mortgage debt and to merge the mortgage title, this will not be so where it is the intention and the interest of the mortgagee to keep the mortgage alive by reason of intervening encumbrances or otherwise, and this can be done without injury to the mortgagor or to third parties. Even if the mortgagee, in consideration of the conveyance to him of the equity of redemption, gives up the evidence of the mortgage debt or acknowledges its satisfaction, this will not necessarily extinguish his mortgage for the benefit of the holder of a subsequent lien. In equity, a merger will not take place unless the purposes of justice or the intentions of the parties so demand. The manifest intention of the parties at the time of the transaction will determine whether the lien is preserved or extinguished. An express written agreement that there shall be no merger will prevent it. The holder of a mortgage may keep it alive as a part of his title after acquiring the equity of redemption, if this is necessary for the preservation of his rights. 58. Conveyance of equity and payment of prior will not advance junior encumbrance. A mortgagee having received from the mortgagor a deed of the mortgaged premises which contained a recital that the deed was to cancel the mortgage, and the land having been taken upon an attachment made before the execution of the deed and consummated by a levy afterwards, and the mortgage and the mortgage notes having been retained by the mortgagee under a parole agreement with the mortgagor to await the result of the attachment, it was held that the taking of this deed did not extinguish the mortgage in favor of the attaching creditor. For one party is not to be estopped by the recitals in a deed which he has taken from giving the truth in evidence to sustain it, against another party who is seeking to go behind the deed to prevent its operation. The retention by a mortgagee of his mortgage and mortgage note or bond, on taking a conveyance of the mortgaged premises, is prima facie sufficient evidence of his intention to keep the mortgage alive to prevent a merger. And if he has cancelled his mortgage by reason of the junior encumbrance having been fraudulently concealed from him, he may by seasonable proceeding have the discharge cancelled and be reinstated in his prior lien over the holder of the junior charge, though this has been refused where no fraud was practiced upon him. So he may have the satisfaction cancelled and his mortgage reinstated if his purchase of the equity, which was the consideration of the satisfaction, is afterwards set aside. If the rights of the parties require it, if for example the conveyance of the equity was made merely for a further security, and it was to be reconveyed upon a fixed payment, equity will regard each mortgage as remaining in force, though a deed of the equity of redemption has been accepted as a foreclosure thereof. 59. When a conveyance of the equity to the mortgagee will be regarded a payment of the mortgage debt. Whether the mortgage debt will be considered to have been paid by a conveyance of the equity of redemption to the mortgagee will depend upon the intention of the parties. Where a mortgager of land by deed, for a valuable consideration expressed therein, conveyed the mortgaged premises to the mortgagee, it was held that, in the absence of evidence that this conveyance was intended by the parties as a payment of the notes which were secured by the mortgage, these notes might still be collected or negotiated by the mortgagee. The owner of an equity of redemption sold it to a purchaser, who assumed the payment of the mortgage. This purchaser gave a second mortgage of the same premises, which was assigned to the first mortgagee, and then conveyed the premises to this mortgagee, with warranty against all persons claiming under him, and a covenant that there were no encumbrances made by him, except the second mortgage. And it was held that the first mortgage was not merged by this conveyance, and the mortgagee could still collect the note secured thereby from the original debtor, whatever the value of the premises. But if a party takes from a mortgager an assignment without recourse of a second mortgage upon the premises, given by a purchaser of the equity of redemption who has assumed the payment of the first mortgage, and who so states in his second mortgage, and if thus holding the second mortgage he then takes an assignment of the first mortgage, he cannot collect the note secured by the first mortgage from the original mortgager. For this mortgager would then be subrogated to the priority of the first mortgage over the second, and thus be enabled to get back exactly the amount he would have paid from the party to whom he would have paid it. The cases just cited hold that a conveyance of the mortgaged premises made by the mortgager to the mortgagee will not operate a payment of the mortgage debt, unless it is shown affirmatively that this was the intention of the parties. If that intention does appear, it will be carried into effect. Elsewhere the presumption has been said to be the other way, that the mortgage debt is paid by such a conveyance, unless it appears that the parties intended otherwise. It has even been held that such a conveyance of part of the mortgaged premises will operate an extinguishment of the mortgage debt pro tanto, but that it will be only pro tanto in extinguishment, although this conveyance of part of the mortgaged property comes from one who had purchased that part from the mortgager and had agreed to pay off the whole mortgage. 60. All intervening estate will prevent a merger. If the holder of a mortgage, which is the oldest lien upon the property, and which is for an amount exceeding the value of the property, takes from the mortgager a conveyance of the mortgaged premises to save the expense of a foreclosure, this will not operate a merger of his mortgage title, so as to enable the holder of a junior lien to take the premises without paying the first mortgage debt. But if the senior mortgagee should purchase the mortgaged premises from the mortgager and undertake to pay the junior encumbrance, deducting its amount from the price of his purchase, this would postpone the lien of his senior mortgage to that of the junior encumbrance. It has been said to be a general principle that whenever the owner of an estate has also a charge upon it, and there is another intermediate charge or estate between his own charge and his ownership in fee, then no presumption without some special act can be made of an intention to merge the charge and the fee, for that might be against the interest of the owner, by letting in the intermediate estate. But if the intervening estate were created by the act of the owner himself, this reasoning would have no application. 61. The doctrine of two funds. Where one creditor holds security upon two funds or estates, with perfect liberty to resort to either for the payment of his demand, and another creditor holds a junior security upon one only of these funds, equity will compel the former creditor to exhaust the fund which he alone can hold as security, before coming upon the latter fund, and thereby depriving the latter creditor of his security. And in a decree foreclosing a junior mortgage, the senior mortgagee may be ordered to exhaust for the satisfaction of his claim all the other property described in the senior mortgage, before resorting to that which is covered by the junior mortgage. If one judgment creditor has two funds out of which he may collect his debt, and a junior judgment creditor can reach only one of these funds, the prior creditor must first resort to that fund over which he has the exclusive control. The junior creditor may also pay off the prior security and be subrogated to the prior creditor's rights over both funds. If the prior encumbrancer does exhaust the only fund which is pledged to the holder of the junior lien, the latter is entitled to be subrogated to the former's lien upon the other fund, or to any balance thereof remaining after the full payment of the prior lien, of which the senior creditor might and should have availed himself. A creditor holding a mechanic's lien, properly perfected, will be protected by the application of the same doctrine. A bank holding a judgment against one of its stockholders, for which, besides its judgment lien upon his real estate, it has also a lien upon his stock, may indeed collect its judgment out of his real estate. But his other judgment creditors, who are thereby deprived of the opportunity of collecting their money, shall be subrogated to the rights of the bank, so as to enable them to hold the debtor's bank stock. As the creditor having the choice of two funds ought so to exercise his right of election as not to injure those creditors who can resort to only one of these funds, so if he, in the exercise of his legal right, exhausts that fund, to which alone the other creditors can resort, equity will place them in his situation, so far as he has applied their funds to the satisfaction of his claim. 62. A creditor whose fund has been taken to pay a prior debt subrogated to the lien of that debt on other funds. If a prior creditor of two funds satisfies his demand out of that fund, which alone is pledged to a junior creditor, and thereby exhausts that fund, equity will subrogate the latter creditor to the former's lien upon that fund, which is not exhausted. A debtor against whom there had been issued executions, which were liens upon his personal estate, having assigned his property to a trustee for the payment of his debts, and directed that the avails of certain cloth should be applied to pay notes given by him to the vendors of the wool which had been used in the manufacture of the cloth, and this cloth having been taken on the executions, the assignee bid it in, and afterwards sold it for a much larger sum. And it was held that the other parts of the assigned property, as between the vendors of the wool and the general creditors, were the primary funds for the payment of the executions, which were liens upon all the assigned property, and that these vendors should be subrogated to the rights of the execution creditors against the other parts of the assigned property, so far as their cloth had been applied to pay such execution creditors, and that the assignee should reimburse himself for the amount of his bid to buy in the cloth from the general fund, so as to give to these vendors the benefit of all the proceeds of the cloth, so far as should be necessary to satisfy their notes. 63. Doctrine of two funds not applied, if it would work injustice to senior creditor. But this general rule, that a creditor having a prior lien upon two funds will not be allowed so to apply them as to exclude a creditor having a junior lien upon one only of the same funds from the benefit of his lien, will not be applied in any case where it would work an injustice to the creditor having the prior lien to restrict him to only one fund. It is never applied where its enforcement would prejudice the rights of the prior creditors or where it would delay him in obtaining his payment. It will not be applied against the prerogative right of the government to hold all the property of its debtor. The prior creditor cannot be compelled to confine himself to only one of the funds, unless that fund is shown to be sufficient to satisfy his demand. He will not be compelled to resort to a fund of which he can realize the benefit only by litigation. If he holds both a prior mortgage and also certain promissory notes as collateral security for the same debt, the holder of a junior lien upon the mortgaged premises cannot require him to prosecute suits upon the notes before foreclosing his mortgage. A mortgagee of both the goods and the accounts of his debtor will not be obliged to collect the accounts and apply their proceeds upon his claim against the debtor, in order to aid other creditors who are unsecured. Or if the prior mortgagee, in an action for his debt, obtains the additional security of a sufficient attachment, but the validity of this attachment is contested in another action, a junior mortgagee cannot require him to litigate this question before resorting to the mortgaged property. Nor will the prior creditor be compelled to go into another jurisdiction, there to prosecute the fund to which he has the exclusive right. But if the avails of property constituting the first fund, though originally beyond the jurisdiction, have been brought within the jurisdiction, the senior creditor must resort to them. And it has been said that the principle that one creditor shall not take a part of a fund which would otherwise have been available for all the creditors, and at the same time be allowed a proportionate share of the remainder of that fund with the other creditors, does not apply to a case in which the first creditor by his diligence obtains something which could not form a part of that fund. But the prior creditor must be able to show what disposition he has made of the fund that was exclusively his, and he may not voluntarily put himself in a position where he will be embarrassed by the enforcement of the rights already vested in the junior creditor. The fact that the prior creditor holds also a third lien on the first fund, inferior in date to the junior creditor's lien, will not be sufficient to exempt the prior creditor from the operation of the ordinary rule. The junior creditor's right of subrogation to the securities of which the senior creditor has declined to avail himself will be preserved after the satisfaction of the latter. 64. Where one of the two funds is itself subject to prior encumbrances. A creditor who holds security upon two tracts of land, one of which is the debtor's homestead, cannot, except by reason of special equities, be compelled by another creditor holding a junior security upon the tract, which is not a homestead, to resort first for the satisfaction of his demand to the homestead, so as to leave the other tract, so far as may be, for the second creditor, and the prior creditor's subsequent purchase of the homestead will not affect his rights. But the creation of the homestead after that of the encumbrances will not affect the rights of the junior creditor. And if the prior creditor had chosen to resort first to the homestead, or even to release the other land, and then come upon the homestead, the debtor could not have complained. There is no implied obligation on the holder of a mortgage which covers both a homestead and other property to exhaust first his remedy against the other property, for the equitable rule that a creditor who has a lien upon two funds, upon one of which another creditor has a subsequent lien only, will be required to satisfy his claim primarily out of that fund on which the latter has no lien, has no application as between debtor and creditor. It avails only as between different creditors of the same debtor. The rights of the parties where a homestead is involved will depend in each state upon the local statutes. In some states, the homestead is favored, and the owner may require even a secured creditor to resort first to the other property. When a person takes a mortgage upon land, of which one portion is, and another portion is not, already encumbered, he acquires the right to satisfy his debt in the first instance out of that property which is not encumbered, and this right will not be impaired by a subsequent mortgage of that part to another creditor. The junior mortgagee cannot require him to run the risk of being obliged to pay off a prior encumbrance before he can enforce his own security. But if the debtor has waived his right of redemption against one creditor, but not against another, the latter has been allowed to require the former to resort first to the exempted property. 65. Doctrine of two funds not applied where it would be injurious to third parties. A junior creditor cannot compel a prior creditor to resort first to that fund which he alone can make available, in any case where this would injuriously affect rights that have vested in others. The prior creditor cannot be compelled to resort first to property which, though pledged for his demand, belongs to another than his debtor. Where a debtor gave to a building association a mortgage of 2 lots of land and an assignment of 5 shares of stock as security for the same debt, and after giving a second mortgage of one of the lots, sold his interest in the stock to other parties, the second mortgagee, although he could require the association to enforce its mortgage first upon the lot which was not subject to his charge, had no right to compel it to appropriate the stock to the payment of its debt. While the principal debtor still owned the stock, it was liable to be applied upon the debt secured by the first mortgage, so as to relieve the security of the second mortgagee. But the burden of this latent equity would not accompany the stock into the hands of a bona fide purchaser thereof for value. The junior encumbrancer cannot insist that the fund shall be marshaled, when the effect of this will be to destroy the remedies or impair the rights of the purchasers or bona fide grantees of one or both of the funds or estate. 66. Where one of the funds is primarily liable for the payment of both debts, there can be no subrogation for the relief of the owner of the fund, which is primarily liable for both debts, the very object of subrogation being to throw the burden upon those parties or that fund upon which rests the primary liability. A testator who held one estate in fee simple and another estate in fee tail left an annuity charged upon all his property. A judgment creditor of the testator, whose judgment was a charge upon both estates, having obtained satisfaction mainly by exhausting the fee simple estate, the annuitant was not allowed to marshal the securities as against the remainderment of the fee tail estate, so as to recoup out of the surplus proceeds of that estate the amount which had been paid to the creditor out of the fee simple estate. To authorize the marshalling, said the Master of the Rolls, it is obviously necessary not only that a claim should exist against a fund subject in common with another fund to a paramount liability, but also that those interested in that other fund should not have a right to throw that liability upon the fund of the claimant. A man's own property, in which alone his legatees can claim, must be applied to the payment of his debts, in preference to the property of another, against which the statute merely gives a remedy. So, a junior firm creditor cannot compel another firm creditor holding a senior lien on both firm and individual property to exhaust first the latter security, though the contrary was held in an early and doubtful case in Tennessee. 66a. Waiver of right of marshaling assets. Though a junior encumbrancer has the right in equity to compel a senior judgment creditor to levy on and exhaust the other property of the common debtor, before coming upon that which is bound by the junior lien, yet if such junior creditor neglects to interfere and assert his right until after the property which he could hold has been sold upon the execution, this sale will not afterwards be set aside for his relief. He will be taken to have waived his right to the application of the rule of 2 funds, unless he presses it before the prior creditor has enforced his securities, and can then have only such protection as he may obtain from subrogation to the prior creditor's rights. The mere neglect of the prior creditor by which his lien upon one of the funds has been lost will not, in the absence of special circumstances, accrue to the advantage of the junior claimant of the second fund. The prior creditor of 2 funds has a right to expect a notification of the right of a junior claimant of one of the funds, if the latter desire to restrict the action of the former. 67. Junior creditor cannot claim the benefit of a lien established subsequently to his own. One lien creditor cannot claim to be subrogated to any security taken by another which had not become a lien when he secured his own. Accordingly, a subsequent mortgagee, having also taken a bond for his debt, but without a warrant to confess judgment, cannot insist that a prior mortgagee shall enter up judgment upon a bond and warrant of attorney that accompanied his mortgage in order to throw him upon other property. Nor can the subsequent mortgagee object to the waiver of a judgment subsequently confessed upon the prior bond, though purposely withdrawn in order to make way for other judgment creditors of the mortgagor, whose liens upon the other property are posterior in date to his lien upon the mortgaged premises. And a junior creditor has no right to object to an appropriation of payments in favor of an earlier lien, so long as the security which he originally had remains undiminished. 68. Creditor subrogated only to a fund which ought to have discharged the debt his fund has paid. One fund cannot be applied to the relief of another by way of subrogation or substitution, unless it is clearly shown that the former fund was liable for the payment of the debt which the latter fund has discharged. The liability of the shareholders in an insurance company being unlimited as to the general creditors, but restricted as to the policyholders, the company borrowed money upon the security of certain calls upon its members. Before this debt was paid, the company was wound up, and the debt was subsequently paid out of the calla. The policyholders desired to have the amount of this debt repaid from the unlimited assets, so as to throw the burden of its payment upon these and not upon the limited assets. But it was held that they bad no right in equity to have the debt thus thrown upon the unlimited assets. Under such circumstances no call could be made upon the shareholders for the purpose of recouping to the policyholders the amount of the capital which had been paid to the general creditors. For the liability of the shareholders is only secondary, and the policyholders could assert no priority in the capital over the general creditors. 68a. Where each creditor has a lien upon the same one of the funds. This doctrine is applicable only in cases in which the senior creditor has a lien upon 2 funds, of which the junior creditor can hold only one. The senior creditor cannot be compelled to resort to property not included in his lien, however this might benefit the junior claimant. Accordingly, where auctioneers held in their hands a part of the proceeds of a brewery which they had sold for a customer, subject to their lien for charges thereon, and also held a second fund for the same customer, being the net proceeds of certain personal property which they bad also sold for him, it was held that they might well apply the first fund to the payment of their charges, and pay over the second fund to their customer, although the effect of this was to leave unprovided for another creditor of the customer, who held a junior charge on the first fund. This junior creditor could not require them to pay their charges out of the second fund, and thus leave the first fund available for his benefit, because they had themselves no lien upon the second fund. 69. Doctrine of two funds applied only if debtors are the same. This doctrine of two funds is applied only to cases in which two creditors have the same common debtor, and only as between the different creditors or others who stand among themselves in the same relation. Where a creditor can hold the joint and several funds of two debtors for the payment of his demand, a court of equity will not qualify this right by limiting the liability of each debtor to one half of the debt. If the first creditor has a judgment against A and B, and the second creditor has one against B, only the latter cannot compel the former to restrict himself to the property of a when it does not appear whether A or B ought, as between themselves, to pay the debt due to the first creditor, and no equitable rights are shown in B, to have the debt charged upon A alone. So also, if one creditor has a lien for his demand upon the property of two separate debtors, and another creditor has a junior lien only upon the fund belonging to one of the debtors, the latter creditor cannot require the former to collect his claim wholly out of that debtor whom the latter creditor cannot reach, unless it be shown that the relations between the creditors are such as to make it equitable that the debtor having but one creditor should pay the whole of the senior demand. For equity will not sanction a principle which, though it may be just as to the creditors, is unjust as to the debtors. But if a partnership creditor has obtained payment of his demand out of the separate property of one of the partners, whom he held as a surety therefor, the separate creditors of that partner may be subrogated to the rights of the partnership creditor against the firm assets, unless it should appear that the partner whose separate property had thus been taken was then indebted to the firm. And the general rule that courts of equity will marshal securities only among creditors of the same debtor is subject to the exception that equity will enforce a duty on the part of one debtor to pay in exoneration of another, by subjecting first the property of the principal debtor. 70. Junior creditor cannot be subrogated until prior creditor satisfied. Before one creditor can be subrogated to the rights of another, the demand of the latter must be satisfied, so that he shall be relieved from all further trouble, risk, and expense. The creditor holding two funds may avail himself of either of them until he has secured his whole claim. And if one creditor has got his payment from the fund which was available to another, under such circumstances as to entitle the latter to be subrogated to the former's claim against another fund, yet the latter must claim his subrogation before the rights of any assignee of that fund have accrued. 71. Application of these principles to a case of several creditors of joint and several debtors. The Pittsburgh Bank, having the first judgment against and lien on the real estate of Peter Peterson, Louis Peterson, and James Kincaid, satisfied its judgment by selling land, which was the individual property of Louis Peterson. The Monongahela Navigation Company had the second, and William Shear the third, judgment against and lien on the real estate of the two Petersons, but not against Kincaid or on his estate. After these judgments, William Taylor obtained 3 judgments against the Petersons and Kincaid, on which Thomas Dale became bail for the stay of execution, and as such paid the 3 judgments after other judgments had been obtained against the Petersons and Kincaid. Among these was a judgment in favor of Sylvanus Lathrop, upon which the real estate of the Petersons and Kincaid was taken in execution and sold, as also under a prior levy upon the judgment in favor of the Pittsburgh Bank. Under these circumstances, it was held that the Monongahela Company was entitled to be subrogated to the rights of the bank, and to have its judgment satisfied out of the money arising from the sale, and then that William Spear was entitled to receive the residue of the money towards the satisfaction of his judgment, but that Thomas Dale could not be subrogated to the rights of the bank or receive any portion of the money, in preference to the judgment creditor of the Petersons and Kincaid, though such judgments might be subsequent to Taylor's judgments. 72. Release by prior creditor of fund primarily liable to him. A prior creditor of 2 funds, who has notice of such a junior charge upon one of those funds that the junior creditor may require him to resort in the first instance to the other fund, will, by release of the fund thus primarily liable to him, postpone his lien upon the remaining fund to that of the second creditor, to the extent of the value of the primary fund. So far as the subsequent creditor is concerned, the debt of the prior creditor is pro tanto satisfied by such a release, and the prior creditor's waste or misapplication of his primary fund will, as to the junior creditor, have the same effect as the express release thereof. Accordingly, where one creditor had a lien upon 2 pieces of land belonging to the same debtor, and another creditor had a junior lien upon one only of these tracts, and the first creditor by his conduct released his claim upon that tract upon which his was the only lien, which was more than sufficient to have paid the whole of his demand, it was held that the debt due to the junior creditor should be first satisfied out of that tract on which both had a lien. Where the agent of a judgment creditor was present at the sale by the debtor to a third party of certain lands on which the judgment was a lien, and drew the conveyance, and was informed of the terms of the sale, and the debtor afterwards delivered to such agent as security for the payments of the judgment debt the notes taken for the purchase money of the lands, it was held that this was sufficient constructive notice to the creditor of the facts, and that the receipt of the notes by his agent with knowledge of their consideration, although it did not destroy the creditor's lien upon the land as security for the payment of his judgment, in case it should not be otherwise satisfied, imposed upon him in equity the duty to apply the proceeds of the notes in reduction of the judgment, and that the creditor was also bound in equity to retain all other property which had been delivered to him as security for the judgment, and to apply its proceeds also upon the judgment, before resorting to the land and taking it away from the purchaser thereof, and that the surrender by the creditor of any such security sufficient to have satisfied the debt, discharged the lien of the judgment upon this land in the hands of the purchaser. 73. But release of primary fund will not prejudice prior creditor if made in good faith and without notice. If, however, the prior creditor's release of the fund primarily liable to him was made in good faith, and without knowledge of the facts which established the claim of the junior creditor, his release will not prejudice his right of precedence in the common fund over the subsequent creditor. Nor will his claims upon the secondary fund be prejudiced unless his rights to the primary fund, which he has chosen to abandon, were clear and not seriously contested, and his remedies for obtaining its application upon his demand were reasonably efficient. Settlement of a contested litigation made in good faith, whereby he receives less than its value from the primary fund, will not interfere with the prosecution of his right to the secondary fund. Although a second mortgagee of part of the same property which is covered by the first mortgage may require the first mortgagee to act with reasonable diligence in enforcing and preserving his rights, yet he cannot in equity compel the latter to account for the value of property covered by his mortgage, which has without his fault been put out of his reach by the mortgagor. The prior creditor's rights will not be affected by his having released one fund, if the remaining fund is amply sufficient for the payment of all the claims. 74. Purchase of a portion of an encumbered estate. Rights of the purchaser. The purchaser of land which, in common with other land, is subject to an encumbrance, for the payment of which the other land is, or has become by his purchase, the primary fund, acquires by his purchase the right of paying off the lien or other encumbrance, and of being subrogated for his indemnity to the rights of its holder. If the mortgage debt is not to be charged primarily upon either estate, he can then require a reasonable contribution from the holders of the other land, the general rule being that when the estates of 2 or more persons are subject to a common encumbrance, for the payment of a common debt, it is to be home rateably by all, and one who pays the whole for the benefit of all will have the right to bold all the estates thus redeemed, until the others shall reimburse him an equitable proportion of the sum which he has thus paid for their common benefit. Or if he has paid his proportion of the debt, and the mortgagee, having sold the other land for enough to pay the remainder, fails to enforce these sales by agreement with the owners of such other lands, the mortgagee cannot afterwards further hold his land for any balance which the other land fails to pay. If, however, the primary liability for the payment of the debt rested upon the estate of him who has satisfied it, then his payment will give him no claim upon the rest of the encumbered property, even though he took an assignment of the mortgage or other charge. 75. Order of liability of separate parcels of encumbered estates sold successively. When different parcels of premises, the whole of which are subject to the burden of a mortgage or other charge, are successively sold to different purchasers with warranty, the rule almost universally adopted to determine the comparative liability of the different parcels is that any portion retained by the debtor or mortgagor shall be first applied to the payment of the debt secured by the charge or mortgage, and if that is not sufficient, Then the other parcels shall be resorted to in the inverse order of their alienation, the parcel last sold being first applied upon the debts, even though a part of the remaining land is situated in another state. The first purchaser from the mortgagor has the prior equity, although he did not actually pay the consideration for his purchase until after other portions of the mortgaged premises had been purchased and paid for by other purchasers. This principle of charging different portions of the mortgaged premises, which have been sold at different times after the execution of the mortgage, in the inverse order of their alienation, is not confined to the original alienations of the mortgagor who is personally responsible for the debt. It is equally applicable to several conveyances of separate parcels of the mortgaged premises made at different times by his grantee, who conveys with warranty. The first purchaser with warranty of a portion of an estate, the whole of which is subject to the burden of a mortgage, judgment lien, or other encumbrance, acquires by his purchase an equitable right to have the payment of the debt, which creates the encumbrance cast upon the remaining property. And each subsequent purchaser of other portions of the encumbered estate takes subject to this right in prior purchasers, and acquires the same right against those who purchase other portions subsequently to his purchase. And the subsequent purchasers have sufficient notice of the equitable charge. For when the records disclose an encumbrance upon property of which a party is taking a conveyance, and also show that this encumbrance rests likewise upon other property, and on an examination directed to this other property disclose the additional fact that a conveyance of this latter property has been made which gives an equitable right to the grantee thereof to throw the burden of the encumbrance upon the first property, the intending purchaser must be presumed to have made such examination, and accordingly to have had notice of such equitable right. Successive mortgagee, to the extent of the interest which they create, are regarded like other conveyances. But this rule has no application to a case in which successive conveyances of different parcels of the mortgaged property have been made to the same purchaser. Nor will it be extended to cover successive sales of undivided interests in the same property, nor so as to cover any case in which its enforcement would be prejudicial to the creditor, and the request for its application must be made before the foreclosure is completed. The same rule has been applied for the protection of a purchaser from the mortgagor of one of several mortgaged chattels, by compelling the mortgagee to resort for his payment first to the chattels retained by the mortgagor. 76. Rule in Iowa and Kentucky. But this rule of applying upon the mortgage such portions of the mortgaged property as have been conveyed by the mortgagor in the inverse order of their alienation has not been followed in Iowa and Kentucky. In Iowa, it is held that where portions of the mortgaged property have been sold and conveyed subsequently to the mortgage, and the mortgagor retains the remaining part, the portion which remains unsold should indeed be first subjected to the payment of the mortgage debt. For although the mortgage is a lien resting upon all the estate alike, yet the mortgagor, in addition to the legal obligations resulting from the stipulations in his mortgage deed, and from the covenants in his deed to his grantee, is morally bound to pay the debt, and to clear away any encumbrance from the property which he has sold. But that, as between the grantees who have purchased different parcels of the encumbered estate from the mortgagor at different times, there is no greater moral obligation to pay the debt resting upon one than upon the other. And accordingly the subsequent purchasers of the different portions of the mortgaged premises must contribute ratably to the discharge of the encumbrance. The same doctrine is maintained in Kentucky, and it has been held in Georgia that the purchasers of parts of the mortgaged property from the mortgagor cannot compel the mortgagee to resort for the payment of his debt to that part of the mortgaged property which remains in the possession of the mortgagor, though their rights against the debtor and against encumbrances junior to themselves are recognized. 77. No distinction between mortgage and judgment lien or other encumbrance. A distinction has sometimes been made between the lien of a judgment or attachment and that of a mortgage. It was decided in Virginia that where a judgment has been recovered against a debtor, which is a lien upon his real estate, and he subsequently conveys his lands by separate conveyances made at various times in different parcels to different grantees, all the debtor's lands in the hands of these respective grantees are alike liable to the creditor, and must contribute to satisfy the judgment pro rata, and not in the inverse order of their alienation. But doubt was speedily thrown upon this decision by the same court which had rendered it, and it has since been expressly overruled. and in Tennessee it has been held that the several purchasers of different tracts of land from one whose real estate is all subject to the lien of an execution are mere strangers to each other. And if some of these purchasers afterwards lose their lands by having them sold on the execution, they have no right either of indemnity or contribution against the others, and no remedy against the grantor, if their purchases were by deed, and without fraud or warranty. But the great mass of the cases put the encumbrance of a judgment upon exactly the same ground as any other encumbrance, as to its effects upon the rights of subsequent purchasers of parts of the encumbered premises. The same rule will be applied to a devise of lands charged with the payment of legacies. Portions of the lands which have been conveyed by the devisee at different times will be charged for the legacies in the hands of his grantees in the inverse order of their alienation by him. And the same rule has been applied to the encumbrance of a widow's right of dower and to other liens upon property. 78. Release of estate primarily liable discharges pro tanto that secondarily liable. From the foregoing rule, as to the order of charging the different parcels of the encumbered premises, it follows that if the mortgagee, with notice of the facts, releases from the lien of his mortgage that portion of the premises which is primarily liable thereto, he thereby releases pro tanto that portion of the premises which is only secondarily liable. For he has thereby prevented the subrogation to which the owner of the latter portion would, upon his payment, be entitled against the former. When after such a release the encumbrance is sought to be enforced against the latter portion, its owner can claim an abatement of his liability to the extent of the value of that portion, which should have been made the primary fund for the payment of the debt. Thus, if the mortgagee of several parcels of land releases one parcel, he will be held to junior encumbrances for its proportionate value. But this would not be so if it was shown that the mortgagor had no title to the lot released, so that the subsequent grantees of the mortgagor could be in no way prejudiced by the release. Nor will the release of a part of the mortgaged premises from the lien of the mortgage in any manner affect that lien upon the residue of the premises, as between the original parties. So far as their rights are concerned, every part of the mortgaged premises is bound for the payment of the whole debt. The release of the primary fund will exonerate pro tanto the secondary fund in the hands of one who has purchased the latter since the creation of the lien, although the release contained an express reservation of all rights against such purchaser. If a mortgagee, having notice of a subsequent mortgage upon a portion of the same land, releases that portion upon which he has an exclusive lien, and which was of sufficient value to have satisfied his whole claim, the court, upon a foreclosure sale of the remainder of the premises, will postpone his claim to that of the subsequent mortgagee. Such a junior encumbrancer has an equitable right to have the property which is not included in his security, but is subject to the prior lien, first applied to the satisfaction of that prior lien to the relief of his security. The purchaser for value and with warranty of encumbered lands and his grantees occupy a position similar to that of sureties for the debtor, and are entitled to the same equities as sureties would be. A release by the creditor without their consent, and with knowledge of their rights, of any security to which they would be entitled on payment of the debt, discharges pro tanto the lien on their property. 79. Release of estate primarily liable will not exonerate estate secondarily liable unless in justice it ought to have that effect. But the rule of charging different parcels of land which are subject to a common encumbrance in the inverse order of their alienation by the debtor being a mere rule of equity, and a release to a subsequent purchaser of one parcel of the land, not being a technical discharge of the parcels previously conveyed from the lien of the encumbrance, it will be treated as an equitable release only in those cases in which, according to natural justice and equity, it ought so to operate against the one giving the release. If the full value of what is primarily liable is realized upon the debt, that is all that can be asked by those interested in the other parcels. Thus, where a mortgagor, having sold and conveyed a part of the mortgaged premises and received full payment therefor, afterwards sells the remainder of the premises to another purchaser for their full value, with the agreement that all the purchase money shall be applied upon the mortgage debt, and the premises thus be relieved from the lien of the mortgage, the mortgagee will not, by receiving the value of this remainder from the second purchaser, and thereupon releasing the land of the latter from the mortgage, discharge wholly or in part the portion conveyed to the first purchaser from the lien of the mortgage for the balance of the debt. The full value of the second purchase having been applied upon the mortgage debt, the first purchaser has enjoyed all his rights, and the mortgagee has not the equitable right further to hold the second tract, of which he has thus once received the full value. If he could bold it, it would be only upon refunding the amount so paid. It has been held that if a mortgagor sells a portion of an estate which is encumbered by a mortgage to secure the payment of various debts, to a purchaser who has only constructive notice of the mortgage, and transfers the notes given by such purchaser for the purchase money to one of the mortgage creditors to be applied upon one of the mortgage debts, the purchaser's payment of these notes to one of the mortgage creditors does not release the land thus purchased from the lien of the mortgage, unless it was so agreed between the purchaser and the mortgagees. A prior purchaser from the debtor who has not yet paid all his purchase money must, to the extent of the unpaid purchase money, contribute to the relief of a subsequent purchaser who has been compelled to pay a common encumbrance, although the latter had agreed with his grantor, the original debtor, to pay the amount due upon the common lien out of his purchase money, if the subsequent purchaser made this agreement in consequence of fraudulent misrepresentations of his grantor as to the amount of the encumbrance. If after the original encumbrance, the debtor first gave a mortgage upon part of the encumbered premises, which has not been foreclosed, and subsequently gave an absolute deed of the residue to another party, then the original encumbrance should be charged first upon the equity of redemption from the second mortgage, and secondarily upon the parcel sold and conveyed absolutely. And if such second mortgagee, after an absolute sale of the residue of the premises with warranty to a subsequent purchaser, takes from the mortgagor a quitclaim deed of the equity of redemption in the property mortgaged to him, and this interest is equal in value to the sum due upon the first mortgage on the entire premises, then the second mortgagee and his grantees should discharge that first mortgage without contribution from such subsequent purchaser. And an assignment of the first mortgage to the second mortgagee will exonerate the lands which have been conveyed to the subsequent purchaser. 80. Release of any remedy to which the subsequent grantee would be subrogated releases the lien on the latter's property. Any act of the prior encumbrancer releasing a remedy to which the grantee of the owner of the equity of redemption would, on paying the debt he entitled to be subrogated, will release the lien of the prior encumbrance on the property in the hands of such grantee. A judgment creditor's voluntary relinquishment of a levy upon personal property of his debtor sufficient to have satisfied the judgment will release the judgment lien upon land previously conveyed by the debtor to a bona fide purchaser for value. If after a mortgagor has given a second mortgage of premises which are subject to a prior mortgage, the first mortgagee, with notice of the second mortgage, diminishes the security of the junior encumbrancer by releasing the mortgagor from personal responsibility for the debt, he will thereby postpone his lien upon the property to that of the second mortgagee. If, with notice of the facts, he gives such a release after a conveyance by the mortgagor to a purchaser of part of the mortgaged premises, who has acquired by his purchase the right to throw the burden of the encumbrance upon the mortgagor and upon the residue of the mortgaged property in his hands, this will discharge the land of such purchaser from its liability under the mortgage, even though at the time of such release the payment of the mortgage debt was assumed by another person, the purchaser not having assented to this substitution. 81. Prior encumbrancer not affected by subsequent alienations of the premises unless notified of them. Before the holder of a mortgage or other encumbrance upon property can be required to act in collecting his demand with reference to the order of subsequent alienations of portions of the encumbered property, he must have notice of what that order is, other than the mere constructive notice derived from the registry of the deeds given subsequently to his mortgage, unless special circumstances have made it his duty to examine the records. He is not bound to take notice of subsequent liens or conveyances, or of litigation which arises concerning them, and subsequent purchasers of portions of the mortgaged premises who desire him to act with reference to the order of subsequent alienations by the mortgagor must notify him of the facts in proper time, and request him to act accordingly. they cannot remain passive until after a foreclosure has been completed, and then set up against the mortgagee facts of which the latter had no knowledge. A second mortgagee or a purchaser from the mortgagor can have the benefit of a release given by the first mortgagee, only where the first mortgagee gave the release with notice of the second encumbrance or conveyance. If the release was given without notice of the equities of the subsequent encumbrancer or grantee, the first mortgagee who gave it is not responsible for the consequences of his act, nor is the lien of his mortgage upon the unreleased portion of the premises in any wise impaired thereby. But if a mortgagee, before giving a partial release of his mortgage, employs an attorney to examine the title to the mortgaged property, the mortgagee is chargeable with notice of all the conveyances thereof found by such attorney upon record, although they have not been communicated by the attorney to him. Actual notice is not necessary in such cases. Knowledge of facts which impose the duty of inquiring before acting is sufficient. But the mere possession of a subsequent grantee is not sufficient, unless the prior mortgagee also knows who has such possession and its character. 82. The mortgagor may by stipulation vary the order of liability. If the owner of encumbered premises, in conveying different parcels thereof, fixes in his conveyances the order of primary liability for the payment of the whole or a part of the encumbrance, then this order will follow the different parcels in subsequent conveyances thereof, even if one parcel comes to the hands of the mortgagee himself. Accordingly, if the owner of mortgaged land conveys a portion thereof of more than sufficient value to pay the mortgage debt, with a provision in the deed that the purchaser is to assume and pay the whole of the mortgage, and afterwards conveys the remainder of the land with the understanding that the mortgage is to be paid off by the former purchaser, and the mortgagee subsequently takes another mortgage upon the portion first conveyed, with notice of the facts, the purchaser of the second lot may maintain a bill in equity to redeem the same without contribution towards the payment of the debt secured by the first mortgage. The contract of the mortgagor is binding upon the land in the hands of any subsequent purchaser who acquires his title with knowledge of his grantor's agreement, and a grantee who has in his deed assumed and agreed to pay a certain amount of a mortgage upon the premises which he has purchased cannot afterwards contest the question of the amount which is due upon that mortgage, so long as he is not called upon to pay more than the sum which he has thus assumed. The prior grantee of a portion of encumbered premises whose grant is expressly made subject to the encumbrance must, for the relief of subsequent grantees of the property, contribute rateably with them for the discharge of the lien, and they must in like manner contribute with him. But mere proof of a purchase of land with full covenants of warranty for less than its value is not by itself sufficient proof that the purchaser undertook to discharge a mortgage thereon of the existence of which he does not appear to have had actual notice. As between a mortgagor and his voluntary grantee with full covenants, the latter has a right in equity, in the absence of any disqualifying facts, to cast the burden of an encumbrance existing at the time of the conveyance upon the remaining land of the grantor, which is also subject to the encumbrance. But if the covenants were inserted without the knowledge of the grantor in a voluntary conveyance from the mortgagor to his wife, then the burden of the encumbrance would not be shifted, and it may be shown by parole evidence that the voluntary grantee understood that the conveyance was subject to the mortgage. The effect of this will be to rebut the equity which would otherwise arise in favor of the grantee, and to subject the portion of the premises conveyed to her to pay its proportional part of the mortgage debt. The general rule that the mortgage will be enforced upon the different parcels, which have since been conveyed in the inverse order of their alienation, applies only where the mortgage is a lien resting upon all the land. Nor can any agreement between the mortgagee and his subsequent grantee of a part of the land diminish the mortgagee's right to hold finally all the mortgaged premises for his security. 83. Extent of the right of a subsequent purchaser. Where lands subject to a judgment lien are advertised for sale under the judgment, and parts of these lands have previously been sold by the debtor, and there are other lands of the debtor unsold, but the judgment lien upon these latter lands would expire before they could be advertised and sold. The owner of the judgment will not be bound, at the request of the purchaser from the debtor, to abandon the sale of the lands which he has advertised. The purchaser's remedy would be to offer to pay the judgment, and then, by his bill in equity against all parties in interest before the expiration of the lien of the judgment, to enforce his equitable rights to contribution and indemnity. After such a tender, the owner of the judgment would have no right to proceed with his levy and sale. If the purchaser's land is sold upon the judgment, he can compel one who purchased from the debtor subsequently to himself to indemnify him, to the extent of the value of the lands of such subsequent purchaser. The purchaser who has not seasonably enforced his right to the proper order of sale can protect his rights only by redeeming from the prior encumbrance, and holding by subrogation the parcels that are primarily liable. A purchaser from the debtor or mortgagor of part of the encumbered premises cannot, against the will of the creditor, redeem his property alone from the encumbrance. He must pay the whole debt. But if the mortgagee or holder of the lien himself becomes, with notice, the owner of the property which is primarily liable for the payment of the debt, and is of sufficient value therefore, then such a purchaser may redeem his property from the encumbrance without paying any portion of the debt. The purchaser of land at a tax sale acquires no such equitable right as a grantee with warranty, and cannot compel a mortgagee to resort first to the mortgagor's remaining land. 84. Instances of the application of these rules. After 3 pieces of land had been attached by a creditor of their owner, the debtor sold and conveyed one of the pieces for value, and afterwards mortgaged the 2 remaining pieces, the grantees in these conveyances having no actual knowledge of the attachment. The attaching creditor then recovered judgment, and the mortgagees purchased this judgment, and levied it upon the piece first conveyed, refusing to levy upon the other pieces, which were sufficient to satisfy their judgment, and it was held that the first grantee acquired by his purchase an equitable right against the debtor to have the other pieces first applied to the satisfaction of the judgment. That the debtor's subsequent mortgagees of the remaining pieces took their mortgage subject to the same equitable burden, and accordingly that their purchase of the judgment did not give them the right to levy their execution on the piece first sold, so long as the other pieces were sufficient to satisfy it. The creditor of a mortgagor levied an execution upon the equity of redemption, and had an undivided share thereof set off to himself in satisfaction of his judgment. The debtor then gave a second mortgage of his interest in the equity of redemption, which was foreclosed. The first mortgagee then obtained a decree of foreclosure against the other creditors, the time limited to the judgment creditor to redeem being a week later than that limited to the second mortgagee. A stranger, at the instance of the second mortgagee, paid off the first mortgagee, and took for his security an assignment of the first mortgage debt and a conveyance of all the second mortgagee's interest in the premises. After this payment, and before the expiration of the time limited for the judgment creditor to redeem, the judgment creditor tendered to this stranger the amount so paid by him, and demanded a release of his interest in the premises, which was refused. The court held that the judgment creditor had acquired by his levy an indefeasible interest in his share of the equity of redemption, with the right, as against the rest of the land, to perfect his title by paying a corresponding share of the debt secured by the first mortgage. That the second mortgagee, by the foreclosure of his mortgage, became the owner of the residue of the equity, with a like right to redeem his share, and that the judgment creditor and the second mortgagee thus became tenants in common of the equity of redemption, each owning an undivided share thereof, and each bound to pay a proportionate share of the prior encumbrance. And that the stranger, having in behalf of one of them paid the whole of the prior encumbrance, could now call upon the other to contribute his proportional share thereof, or to be foreclosed of his interest in the equity of redemption. C. Sold 50 acres of land, and took from the purchaser a mortgage for $870 of the purchase money, and afterwards purchased a farm from K, and mortgaged it back for the purchase money, and as a further security assigned to K. The mortgage upon the 50 acres, and both of these mortgages were afterwards assigned by K to J in payment of a debt, C, then sold and conveyed the farm with warranty, and the farm subsequently came by mean conveyances to S, J, then obtained a decree to foreclose the mortgage upon the 50 acres, and C afterwards repurchased the 50 acres and agreed with the mortgagor to satisfy this decree of foreclosure, but failed to do so, and afterwards conveyed the 50 acres to a bona fide purchaser for value. It was held that the mortgage upon the 50 acres was the primary fund for the payment of the debt to J, and that S, who had obtained an assignment of both securities, was entitled to enforce the decree upon that mortgage for the payment of the balance which was due upon it. The holder of a large tract of land subject to a vendor's lien sold and conveyed some portions of it with warranty to different purchasers, and then died, leaving a will, by which he charged with the payment of his debts some of the parcels that remained his property, and devised the residue to his children. His executor having sold the parcels charged with the payment of debts, the purchaser of 2 lots paid the price of one, but failed to pay for the other, which upon his default was sold again, for less than the amount which he had agreed to pay. This new purchaser then bought the decree which had in the meantime been obtained to enforce the original vendor's lien, and attempted to subject the other portions of the land to its satisfaction, and it was held that the lot bought and paid for at the executor's sale must be first subjected, because its owner was primarily liable for both lots, and that the new purchaser and the several divisees must contribute ratably to make up the deficiency according to the present value of their respective lots, relieving the grantees with warranty of the testator in his lifetime. A debtor, having given a first mortgage of a lot of 360 acres of land, and then a second mortgage of all but 75 acres of the lot, and then a third mortgage of the whole parcel, it was held that the second mortgage might require that the first mortgage should be enforced first upon the 75 acres not included in his second mortgage, and that the third mortgagee had no right to call upon the second mortgagee to contribute pro rata to the satisfaction of the first mortgage debt. A railroad company having taken for the construction of its road the title to a portion of a piece of land upon which there was a prior mortgage, of which it had constructive notice, it was held, upon a foreclosure of the mortgage and a sale in parcels of the whole of the mortgaged premises, that the company was bound to contribute to the payment of the mortgage debt, if the same were not paid by the sale in the immerse order of alienation of the other property covered by the mortgage, the full value of the land which it had taken as of the time of the taking, with interest to the time of payment, so that the railroad company was in effect allowed to redeem its land from the mortgage lien by paying a ratable proportion of the mortgage debt to the extent of the full value of the land at the time of their taking it with interest. The owner of 2 tracts of land, having given a mortgage of both tracts, sold one of the tracts to a purchaser, who, by the forms of his deed, assumed the payment of the whole mortgage debt, and also gave a mortgage back to his grantor, conditioned to save him harmless from the original mortgage. This purchaser afterwards sold his tract to other vendees, the amount of the debt due upon the original mortgage being deducted from the price. This tract was held to have become by these conveyances the primary fund for the payment of the mortgage, nor did it cease to be such because the original owner afterwards agreed to discharge his mortgage, for that was a mere personal security to himself. 85. When the purchaser of an equity of redemption assumes the payment of the mortgage, it is generally held that an agreement by the purchaser of an equity of redemption with his vendor that he will himself assume and pay the mortgage debt will render him personally liable, not only to his grantor but also directly to the holder of the mortgage, and that without affecting the liability of the original debtor. The original doctrine, which is still often supported, was that this right of the mortgagee to hold the purchaser of the equity of redemption, by reason of the latter's agreement with the mortgagor to assume the payment of the mortgage debt, does not mean that the mortgagee can maintain an action at law upon this agreement between the mortgagor and the purchaser, but rests on the ground that the contract of the purchaser is a collateral stipulation obtained by the mortgagor, which by equitable subrogation inures to the benefit of the mortgagee. The mortgagee is said to stand on the rights of his debtor, and to be entitled to appropriate for his debt any security held by his debtor for its payment, and his remedy is restricted to the privilege of subrogation to the rights of high debtor, and will give him no rights against the purchaser which could not under the contract of purchase have been claimed by the original debtor. Accordingly, the mortgagee has been allowed to enforce the personal liability of such a purchaser only to the extent of the deficiency upon a foreclosure sale of the mortgaged premises, and only if the party to whom the purchaser's agreement was given was himself personally liable for the payment of the mortgage debt. The doctrine of equity is that, when the grantee in a deed assumes the payment of the mortgage debt, he is to be regarded as the principal debtor, and the mortgagor occupies the position of a surety. and the mortgagee is permitted to resort to this grantee to recover the deficiency after applying the proceeds of a sale of the mortgaged premises, by the equitable rule that the creditor is entitled to the benefit of all the collateral securities which his debtor has obtained to reinforce the principal obligation, though this right is strictly an equitable one and its exercise at law has been refused. But the broad doctrine has since been laid down that one for whose benefit a promise is made to another may maintain an action upon the promise, though he was not a party to the agreement or privy to the consideration thereof. And it was then held in unqualified terms that whoever has for a valuable consideration assumed and agreed to pay another's debt may be sued directly by the creditor, and that a mortgagee or other encumbrancer may maintain a personal action against a purchaser from the owner of the equity of redemption who has agreed with his grantor to assume and pay off the encumbrance, if the party with whom the agreement was made was himself personally liable upon the mortgage debt, and that a purchaser who has made such an agreement cannot afterwards be released therefrom by his grantor, to whom it was made, without the consent of the creditor, to whose benefit it inures, if the latter has accepted it. The same rule will be applied to the case of any other encumbrance. But the mortgagee can simply hold such a purchaser to the performance of his agreement. He will not be subrogated to any other right against the purchaser. The development of this doctrine, though doubtless an outgrowth of the law of substitution, scarcely comes within the scope of this investigation. It is sufficient to say that it has also been emphatically denied. And the court which laid down this proposition in its broadest terms has refused to apply it to other somewhat similar cases, and has said that the rule is one which ought not to be extended.